Secretary Fox Tolentino, Attorney General Brown, Mary Scally, Natasha Dartique, and Dorothy Lenning.
All right, and then maybe Mary will show.
All right, thank you. You may begin.
Thank you very much. I appreciate it. So good afternoon, Chair Davis. Good afternoon, distinguished members of the House Judiciary Committee. I come before you today in support of House Bill 409, the Youth Charging Reform Act. So I'm going to tee up the bill, and then I'm going to let my experts who are beside me and around me go through the technical details of the bill. First, no doubt, I just want to tell you, this is not a simple bill because juvenile law is complex, but we are called here to do complex things. And as the speaker always says, we can walk and chew gum at the same time. House Bill 409 balances the complexities of child development with public safety and rehabilitation, juvenile services operations, juvenile detention operations, youth accountability, the concept of justice, established youth brain science, and juvenile court jurisdiction. So let's walk through the bill. First, who are we talking about? If enacted, House Bill 409 only expands the juvenile court's jurisdiction for 14, 15, and 16 and above. 14 and 15-year-olds would be included, those that have alleged to have committed an act that, if committed by an adult, would be a crime punishable by life imprisonment. The bill also includes someone at least 16 years old alleged to have committed certain offenses, which we will be discussing. However, under the bill, adult court would still have jurisdiction over a child at least 16 years old who is alleged to have committed any crime punishable by life imprisonment. So what crimes, as I said, we will talk about. For a child, I'm sorry, I'm scrolling up in the interest of time. So what happens now? What is the current process? I'm going to do my best to explain it, but my experts will explain it even better, and practitioners will explain it even better. So now we have what's called a reverse waiver when someone goes back to juvenile court jurisdiction, or the juvenile court jurisdiction could waive their jurisdiction, and the child could go to adult criminal court. So you'll hear terms like waiver, and you'll hear transfer. Transfer in the case back to juvenile court before trial or before a plea upon a determination by the court based on a preponderance of the evidence that the transfer to a juvenile court is in the best interest of the child or society and certain conditions are met. That's considered the reverse waiver. So how often does this happen now? And is it the most efficient or humane way to handle our children? So we're talking about children who start in adult court and wait and wait and wait and wait and wait. I could be here all day with this because you know why? Some children are in for an adult court, the adult court jurisdiction for 140 days or up to 900 days, as I spoke of before in previous testimony. So why does this happen? Why are children first charged as an adult? We know children are children. We know that that's bad for them. We know this. There's no debate that anyone could ever win if they say it is good brain science, it is good government to lock a child into restrictive housing for 140 days or 900 days without education, without therapy, without educational services, without even having a hearing. But it's what we do. We did the same thing if you think about it. I'm going to give you the analogy. Social media. We knew that social media was bad. We knew that people not talking to people would be a problem for such a social community as young people, but we did it anyway. Now, what are we doing? Trying to fix the problem. And in fact, we know, given the hearing that we just heard, putting kids, foster kids in hotels, we know that that is bad. But what did we do? We had to wait until we lost one of our angels. And then we're ready to do something. I'm asking you, let's not wait until we lose one of our children and then we're ready to change the trajectory of Maryland. Maryland is an outlier in this. I've attended national conferences, state legislative conferences, just like you all have. And quite frankly, there are red states and there are blue states that do not have the same practice that Maryland has, where we charge children first as an adult, and then we make them prove that they are children. So with that said, I ask you all for a favorable report on House Bill 409, and thank you.
All right, who's next? Proceed as you like.
Chair Davis, members, good afternoon. I'm Natasha Dartigue, Maryland Public Defender. I start with something simple. These are children. When a prosecutor files charges in adult court, the child is placed in solitary confinement. Federal law requires sight-sound separation for adults. There is no other option. 22 to 24 hours a day in a cell, no school, no services, no support. We have not created a justice system for children. We have created a trapdoor. The science is clear. The part of the brain that controls judgment develops slowest and last. Isolation during critical years causes permanent damage. Children in adult facilities are 36 times more likely to commit suicide than in juvenile facilities. We are making them worse, then release them and wonder why children tried as adults are 34% more likely to reoffend. We build that outcome. We should own it. Even harder to justify are the 85% of cases that end up dismissed or sent back to juvenile court. Children that have waited in a cell, lost months of school, suffered harm, we cannot undo. We must ask ourselves why. There is an overcharging problem. Prosecutors are filing in the wrong forum. Every case transferred back is a child who went through that trap door for nothing. 80% of the children caught in the system are Black. Not a coincidence. It is a pattern this committee has the power to correct. The juvenile system is not the problem. Maryland Rule 11-421 requires adjudication in 30 to 60 days. Adult court takes an average of 200. Juvenile court is faster, provides services, and produces better outcomes. Start these cases where they belong. OPD urges a favorable report on House Bill 409. Thank you.
Thank you.
Good afternoon, Chair, members of the committee. I'm Betsy Fox Tolentino, the Acting Secretary at Maryland's Department of Juvenile Services, and we are here today in support of House Bill 409. At its core, this bill is about public safety and fairness, and making decisions at the right time by the right people using the right information. The right time is early, before months of delay occur. The right people are judges, not at the moment of arrest. And the right information includes a youth's developmental status and amenability to treatment. The research is clear. Youth prosecuted in adult court are more likely to reoffend and to commit more serious offenses than those comparable youth served in the juvenile justice systems. Earlier access to developmentally appropriate accountability and treatment reduces recidivism, which means fewer victims and safer communities. It is also important to be clear. House Bill 409 does not shift a new population into the juvenile justice system. DJS is already serving these young people. The overwhelming majority of youth charged with the offenses addressed by this bill ultimately return to DJS custody. We supervise them safely every day in secure residential settings and in the community. DJS has shown that accountability and rehabilitation go hand in hand. Youth are held accountable through structure, supervision, and court oversight, while treatment addresses behaviors. Under current law, automatic charging makes one of the most consequential decisions in a young person's life at the moment of arrest, before any judicial review. This creates long delays and real harm. Youth can wait 150 days on average, and sometimes up to 2 years before they have a hearing to determine what system their case will be heard in. These delays leave youth in adult jails longer than appropriate, directly contributing to Maryland's continued noncompliance with the Federal Juvenile Justice and Delinquency Prevention Act. What we have today is a lengthy system that prioritizes punishment over timely accountability. House Bill 409 preserves adult court for the most serious offenses while ensuring earlier informed judicial review, so accountability and intervention can occur when it matters. And for these reasons, DJS respectfully urges a favorable report. Thank you.
Thank you.
Yes. Madam Chair, members of the committee, thank you for the opportunity to testify today in support of House Bill 409 with amendments. And I want to thank Delegate Bartlett for your leadership on this important legislation. I've submitted written testimony that provides greater detail and background on the positions I'm presenting today, along with detailed references for the facts and data. House Bill 409 implements key recommendations from the Maryland Equitable Justice Collaborative, limiting the automatic adult charging of children to address systemic inequities in our juvenile justice system. The impact of our current practice disproportionately impacts Black children. While Black children make up only 31% of Maryland's youth population, they represent 81% of those charged as adults between 2021 and 2023, making them more than 7 times as likely to be charged as adults as their white peers. And here's what's most troubling. Roughly 85% of youth automatically sent to the adult justice system either have their cases dismissed or are sent back to the juvenile system, a significant system failure that exposes children to adult court proceedings without ultimate adult prosecution. And during the pendency of these charges, youth receive few, if any, rehabilitative opportunities. Even youth whose cases are ultimately dismissed have been denied access to educational, mental health, and rehabilitative interventions. House Bill 409 aligns Maryland with national best practices. More than half of all states have recently narrowed eligibility for children being charged as adults, and 8 states now require all juvenile cases to start in juvenile court. That's why we support this bill, prioritizing rehabilitation over punishment and providing children with appropriate opportunities for treatment and reform is the right approach for Maryland. My written testimony outlines one amendment that we seek. It is not essential for the passage of this bill. We think it's a good amendment. It strengthens the bill. It protects our community. It recognizes the need to focus on rehabilitation and not punishment. If this committee believes that that amendment is not worth passing, please pass this bill. It is long overdue. Thank you.
Thank you.
Good afternoon, Madam Vice Chair, members of the committee. My name is Dorothy Lenig. I'm the Executive Director of the Governor's Office of Crime Prevention and Policy. I want to thank Chair Bartlett for introducing this bill. Now, you might wonder, why is GOCAP involved in this bill? It's illegal to hold a youth in an adult detention facility for more than 6 hours under most circumstances. And as you've heard, the child has to be separated by sight and sound, which makes them basically in solitary confinement. It's GOCAP's responsibility to monitor whether Maryland is following the law and counting the number of youth who are sitting in these facilities for a longer period of time. Maryland is seriously out of compliance. GOCAP staff counted the number of youth out of compliance for a 5-month period in 2025 and found 320 youth. They were sitting in an adult facility for an average of 25.4 days, and we were out of compliance in 20 jurisdictions. The reason that youth get held in adult facilities is because sometimes the DJS pretrial holding facilities are full. And the reason the DJS pretrial facilities are full is because, as you've heard, it takes longer for cases to be adjudicated in adult court than it does in juvenile court. By law, juvenile court moves more quickly. So how will this bill help? If we automatically charge fewer youth as adult, instead of charging them as juveniles, the youth will be found adjudicated, guilty or not guilty, more quickly, and move these kids out of these pretrial facilities more quickly, making room for more youth. After adjudication, the youth might be sent to a locked facility, they might be put on probation, they might be found not guilty. The most important piece is the youth who are found to need additional services will begin to get those services more quickly than a youth sitting in an adult facility who are receiving no services and no schooling. This bill continues to hold youth accountable for their actions. It just simply moves them through the criminal process more quickly, gets them to rehabilitative services more quickly, and brings Maryland into compliance. We urge a favorable report on House Bill 409. Thank you.
Madam Chair, just
Thank you.
may I make one quick remark? I'm putting on my chair hat for 1 second. Even for my bill, we cannot allow demonstrative signs or anything of that sort. So I'm not going to turn around, but I am seeing them, and I'm sorry, friends, they've got to go. If you're holding a sign, you've got to take it away. Thank you very much.
Thank you, Madam Chair. All right, questions, please. Delegate Phillips and then Delegate Carton.
Thank you, Madam Chair. And my first question is to Madam Chair. This body, eventually I think this mic is going to come on, but I speak loud enough. So this body, a couple of years ago, passed legislation to create a commission to study best practices for juvenile justice. And you are a member of that commission. That commission has taken one major action. And what is that action? What was that action? And who's on that commission? And what was the recommendation?
Well, thank you for that softball question. So, yes, in fact, I am on that commission, and you serve on that commission with me. We hear often, and we have the DJS Secretary Tolentino's office is present. We have the Office of the Public Defender present. We have senators who are assigned to that commission, as well as law enforcement, judges. In fact, Judge Davis is the chair of the committee. We also have members from the community. We have state's attorneys. We have, justice or parents of justice law-involved children, and I believe we even have some members from the victim community.
And what was that recommendation coming from the commission?
And that recommendation was one and only one, and that was to support this bill.
Thank you. Can I ask a question of the secretary? So, Madam Secretary, I know in my conversations with state's attorneys, they talk about this number of 85%, and they suggest that 85% of those youth that go back to the juvenile system is not quite 85%. So before they come up and try to debunk this, can you explain what that number is that we end up bringing back?
When you hear that larger number, DJS is reporting out the number of young people who are transferred back to the juvenile system and or had their case dismissed, right? So these are the kids who their cases were disposed of and the kids who are coming back to the juvenile justice system. And, mainly, I think where the data is challenged is when we look at specific jurisdictional numbers, because that's a statewide number. And if we look at different jurisdictions, the number's gonna look different. And we have different data sets. We talk about the different data a little bit in a different way. DJS partners with the Commission on Juvenile Justice Reform and Emerging Best Practices to track youth charged as adults across agencies. And this is the first time we've done that, where we've been able to really track how youth are experiencing this system. The Baltimore City State's Attorney has also recently released a report that includes some data. And this report actually confirms the strength of DJS data collection and reporting, because although there are differences in the way the data is presented, the information reported by DJS and the Baltimore City State's Attorney are largely consistent with one another. Our data shows that about 55% of the youth that come back to the juvenile justice system in Baltimore. But we also paint a fuller picture by including the percentage of cases that are dismissed or otherwise disposed of, which is about 20%.
So my last question, because I know people have a lot of questions to ask. There's always this concern about those individuals, and I'm going to use handgun violations. What is DJS's typical process for making a detention decision? People want to make sure that folks are safe, and they want to make sure that if there are issues of safety that they're being addressed. So how do you handle those?
So when a young person is arrested and brought to the attention of the Department of Juvenile Services and law enforcement asks for detention, then we do a review of the case and we do an assessment of the youth. We use a validated risk assessment tool to help us make our detention decisions. We're required to do that by law. We're also required to have that tool validated every 5 years. The tool was recently validated about a year ago, and in coming into this agency about 6 months ago, I did a really deep dive to see how the tool is operating, what the research looked like, because we have it validated by external researchers. And I want to make sure that, yes, this tool is predictive of whether or not a young person is going to commit a new offense or show back up to court. And I feel very strongly that the tool is a good tool. What I didn't like is how we were using our objective risk assessment tool to help us inform decisions. And so over the past few months, we've been reprogramming all the different things we need to reprogram to release an updated detention risk assessment instrument. That will go live on the 18th, actually. And when we're using risks to help us make those decisions, whether to release a young person, put them on community detention, or detain them, we just do that for until the next court day, and then the court reviews detention decisions and community detention decisions. But if a young person comes in with a handgun violation, we will automatically detain that young person. We will also automatically detain young people who are charged with a category 1 or 2 offense, which is essentially our crimes of violence.
Thank you. And if I could, just one more, please. Because I want to make an observation, because there's been a lot of talk about the disparities in youth who are charged as adults. And it's been a lot of years since I practiced in kind of that area, but I don't think it's changed much. Either the Attorney General or OPD, Madam OPD, do you see a difference from a socioeconomic standpoint, not just race, but for those individuals who have private counsel, for those parents who bring in representation, for those that are charged as adults, versus those that are charged as children? Just adding that.
May I ask you to rephrase the question, please?
So, my sense is we talk about the number of African-American youth that are charged as adults. And my sense, and this is what I'm asking you, for those individuals who can provide private representation or engage their parents immediately, they have people that are engaged, are they more likely to be charged as an adult or a youth?
So in all candor, I'm not clear to your question, so I will answer in terms of what I understand. And from the perspective of the Office of the Public Defender, where we represent a majority of individuals that are charged with criminal offenses, and that includes children. So the population of children that you see is 80% Black children coming from marginalized communities. So large percentages of children would therefore come to the Office of the Public Defender. It is part of a bigger system problem, because now we're getting into what communities are over-policed, and that's where you see larger frequency of those who are arrested, and from those communities you'll see the numbers.
That's fine. Thank you.
Thank you. Delegate Cardin and then Delegate Simmons, please.
Thank you very much, Madam Chair. Thank you all very much for the very compelling testimony. And Madam Chair, as you know, or maybe you don't, I came to the previous chair the last 2 years and was very highly considering being the lead sponsor on this bill. And so I'm interested in it. That being said, the fiscal note indicates, this is from, the first question is from Ms. Dartiche, right?
Dartigue, like fatigue.
Dartigue, I apologize. The fiscal note indicates that there's going to be approximately a $1.4 million savings or reduction to the appropriation for the public defender because of cost, because of savings for this. Are you guys prepared to reduce your budget by $1.4 million? In addition to that, the judiciary says in their testimony that that this could, there's equal concern that the public defender's lack of sufficient juvenile justice panel attorneys could cause major delays in justice for youth. So that would be question number one. Do you mean to just do both my questions? Question number two is that I looked through all the testimony. I didn't see anything from the Women's Law Center, MCASA, or National Association Against Domestic Violence, and the other organization that came testify on a number of bills. One that would convert a 4th-degree sex offense to a 3rd-degree sex offense, increasing penalties for youth, not differentiating between youth and non-youth. And in other bills, which, by the way, I'm not necessarily saying I'm opposed to. I like the legislation, but we're going to be treating 16-year-olds who are potentially committing an alleged rape against a person, perhaps with a gun to their head. None of that is necessarily a life sentence, and they're going to be treated as juveniles, and I would think that the victims would be concerned about that. So those are my two questions that we have to make sure we're just being transparent about.
So I will answer the first part in regards to resources and funding. The Office of the Public Defender is an under-resourced agency, and we provide quality representation that includes social workers, investigators, mental health professionals. We currently handle cases, juvenile cases, throughout the state, and we do it with expertise in the juvenile arena. So in regard to your question, our ability to do the work, we do it now and we do it across the state. So no, OPD would not be able to take any hits in funding. It would not be appropriate for an agency that is under-resourced. But what I would say is that this reform would essentially free up capacity, because the process goes from 200 days in which my expert attorneys are litigating transfer issues to 30 to 60 days where they can resolve the issue. In regards to what you spoke about in terms of the judiciary, that is a separate problem that is created by the overcharging of the state's attorney's office. Because what we have, for example, is there are 4 children in a car, a driver and 3 passengers. So I say, I'll use myself as an example. Natasha is the driver. She picks up her friend Betsy, and then they go and they pick up their friend Anthony. We all go for a ride. The car is stopped, and now it's a 2025 car. There's no key, there's no popped ignition, no indicia of being stolen. So Betsy got in the car and Anthony got in the car, but the car is stopped, and all the children are arrested and charged as adults. So in that scenario of overcharging, where at best maybe the most culpable is Natasha, the driver, Betsy and Anthony are also charged. What ends up happening in the overcharging, the Office of the Public Defender would represent the one deemed to be most culpable, Natasha, but then has to file a panel attorneys. As the case moves through the 200 days, it's shown that in fact, Betsy got in the car an hour later and she didn't know it was stolen, as did Anthony, and those cases are dismissed. That is the issue in terms of overcharging, because what happens is I, as a public defender's office, have to find a panel attorney for Betsy and Anthony, even though the cases are ultimately dismissed. That is a waste of resources.
Thank you.
And I defer to the second part to Madam Chair.
All right, we've got some other questions.
He had a second part.
Oh, I'm sorry.
Yeah. The second part of your question, if I understand it, Delegate Cardin, is where is the testimony from anyone in the survivor community, sexual assault community? And my answer to you is, as diligent as that community is, and as vocal as that community is, given the lack of testimony from that community, I can very clearly state that they are not opposed to the bill. And in fact, I did receive a text just a moment ago stating that they are not opposed to the bill. So thank you.
Thank you. Delegate Simmons?
Thank you, Madam Chair, and thank the panel for coming out. And Madam Secretary, thank you for coming back. So when we look at overcrowding of our correctional facilities when it comes to juvenile detention, and we look at the crimes that are taking place in that area, can you tell me, are we housing out-of-state youth based on the scenario of these, how and where we can house them?
So today, in my juvenile detention facilities, about 60% of the population that we detain are youth charged as adults, so the majority. In my long-term treatment programs, overall about 57% are youth charged as adults or had their cases start in the adult system. And we utilize nearly 27 different committed facilities to serve our youth charged as adult population, or those who started their case in the adult system and come back to the juvenile system. So the majority of the work I'm doing is for kids who start their cases in the adult system. I do have a few of kids who started their case in the adult system who are being served out of state. I do not serve out-of-state young people in our facilities, so kids coming from other states, unless it's a runaway situation and there's been some sort of warrant.
Sure. Can you give me an idea where they're being housed out of state?
I can. I actually have that right in front of me, right here. So I have one out of state in Delaware, two in Delaware, and one in, oops, I don't have the location of where this other out-of-state program is. I'll have to get back to you on it, but I have two in Delaware and one in another
Sure.
out-of-state
And
program.
I appreciate that. I know we are talking about the conditions in which our youth are being housed. Can we attest to the conditions in which they're being housed out of state?
Absolutely. We have licensing and monitoring agreements with the facilities that we utilize out of state. We ensure that they are compliant with all the regulations that they have to for their state, as well as the federal regulations. Our licensing and monitoring team go out frequently to check on the facilities, and also our case managers will go out and visit the young people. Our young people also have access to able to file a grievance or reach out to us at any time.
Sure. And then my last question, due to the fact that they are out of state, are any of those youth that are out of state being represented by the Office of the Public Defender?
Most likely, I don't know where the representation's coming from, but the Office of the Public Defender represents nearly all youth in our system. So most likely they are, but they may have private counsel.
Thank you. No further.
Okay, I am told we have technical difficulties. We need to take like a 30-second break. Thank you. We're back on. I am going to, Delegate Embry, do you still have a question?
I do, I'm sorry.
Delegate Embry, Delegate Taylor, and then back to this side of the room.
Thank you so much. Thank you, Madam Chair, and the wonderful panel. This question is for the Secretary. One of the issues that's been raised is the waiver process, and that is sometimes challenging for prosecution, specifically that a youth might not be motivated to be involved. Could you talk through that process and your thoughts about the concerns raised by prosecutors?
So when a youth is charged as an adult, we have to do a transfer report. The department is ordered to provide a report that states it's basically a psychological assessment, what services, what needs the youth has, so that their prior history, educational, it's a very in-depth sort of analysis of what's going on with that young person. And that's presented to the court when that transfer hearing asking for to go from the adult to the juvenile system is held. And in that situation, the youth has the burden to prove to come back to the juvenile court. If we started the cases in the juvenile court, the state's attorney would be empowered to say, hey, I want to ask for a waiver. In that situation, they would be asking to waive the young person from the juvenile court up to the adult court. Again, I still have to do a big report. We call it the waiver report. And it looks at all the same things that our transfer report would look at. The difference is the state's attorney has the burden in that hearing to prove that the youth should go up to the adult system. And I think the concern is that youth wouldn't have really any reason to sit for that waiver report for the psychological assessment and background social history because they have their own rights and there's not much incentive. And that logic actually just doesn't flow for me. One of the biggest factors that the court is looking at or is told to look at through our laws is whether or not the young person's amenable to treatment. If the young person isn't going to even sit for an evaluation, I think it's pretty easy to say they're probably not going to engage in any treatment. So I think the youth would be in a really bad position if they didn't sit for those reports. And if the report wasn't completed, I would assess or assert that the state's attorney would say, well, they're not even going to sit for an evaluation. How would they engage in treatment? So I think that's the concern. That's my sort of analysis of that concern. I'm sure there's other opinions, but I think that, you know, there are protections to ensure the young person engages in those evaluations, and I believe they absolutely would. And we've never seen a situation where they refused.
Thank you very much.
Delegate Taylor?
Thank you, Madam Chair. This question actually goes to Prince George's best, Attorney General Brown. You have an amendment, and I'm reading your testimony. It talks about a pattern of violent crime. There's a definition there. I'm happy to wait if you want to, if there's another person, if there's somebody from your office that's going to go into more depth about this amendment later in another panel.
You got the best. You got the best.
Got the best here. So please, can you talk a little bit about why you proposed that amendment and how you think that it makes this bill better? And then, Madam Chair, I have 1.5 more questions after that.
So the amendment, which because of time I didn't describe during my testimony, it proposes adding a pattern of violence, a violent crime definition, and an exception for children at least 16 years old who are alleged to have committed 2 or more serious violent offenses within a 6-month period. And where those offenses by themselves would not result in adult charging, but if 1 or 2 or more are committed within a 6-month period, such as armed robbery, home invasion, first-degree assault, so long as they are in the same indictment and not the result of overcharging, where you have, one misconduct or one offense where you have 2 or more charges for the same offense. So in a 6-month period, 2 offenses or more, that would meet a pattern of violent crime definition, and that could be charged is in adult court. That's what we're proposing as an amendment.
Got it. Thank you. Another question. The State Advisory Group has testimony here too, and I actually sit on that advisory group as well as Madam Chair. And being a part of that group, and I know you've mentioned that, Ms. Lennick, that the state of Maryland is out of sight and sound compliance and maybe some other out of compliance issues. Why doesn't this bill go far enough potentially to address whether, according to the testimony, this bill may not go far enough in addressing the violations. Do you have any comment there as to why not and what we could do potentially to address them?
I mean, as you know, I'm sort of new to this issue in my role at GOCAP, but as I understand it, the problem is that somebody's arrested, not in Baltimore City because they have the juvenile detention center, so it's really not there. It's really most other jurisdictions. They get arrested, they're charged as an adult, they go to an adult detention facility, the county jail,
Right.
and they sit there until there's a place where they could be in a juvenile facility. If they're charged as an adult and they're going through the adult system, it can take a long time. Whereas if they're charged as a juvenile, that process just goes much more quickly. So the reason the juvenile pretrial facilities, I'm using the adult terms, I think what's confusing, especially for the other lawyers, is that some of the juvenile terms for how people move, they're different. And so I didn't understand what they were. So let's use the adult terms. They're sitting there pretrial. If they were sitting in a pretrial juvenile facility, they'd be okay. That you can still hold them accountable. You can still make all the same decisions. They'd just be sitting in an appropriate facility, getting schooling, getting some services, until you can decide what the appropriate punishment is or what kind of rehabilitative services we're getting. But because the juvenile pretrial facilities are full of these kids who are waiting to move through the adult system, there's just a lot of them there. And if we could move them more quickly through there, then we'd open up more space. So if they're sitting in Dorchester County, we could get them into a juvenile facility more quickly. From where I sit, it's not so much whether we're giving them the appropriate treatment once they're adjudicated, once they're found what we would call guilty.
Yeah.
Whether they're getting the correct services there is kind of a different question. To me, this is a question of let's get them through the court system more quickly and figure out what's appropriate for that juvenile. Having them sit in an adult detention center, basically in solitary, no school, no services, just is not a healthy way to treat a child.
And I'll also state that I'm looking at the SAG testimony, and they're stating essentially that while this would get some kids out of adult jails, it's not enough to get Maryland completely in compliance with JJDPA, the Juvenile Justice Delinquency and Prevention Act, because we would still have some other kids that could be in adult detention. And therefore, we would not necessarily be in compliance with the separation of sight and sound.
Thank you, Madam Chair. And that kind of tees up my half question, which says that, there are 8 states that already require that all juvenile cases go straight to juvenile court. Why aren't we considering that as well?
I guess I have to answer that question. I will tell you that I am big on getting done what I can do when I can, and that's what's happening here.
Thank you. Delegate Conaway.
Chair, thank you, Delegate Chair and panel for coming in to testify. So if a juvenile, say 13 years old, is found possessing a handgun as first charge, would that juvenile be charged as an adult? And that's one question. In reference to overcharging, when a gun is found under the passenger seat of a vehicle and there's several people in the vehicle, who gets charged? And in reference to both of those questions, when does the school system teach these concepts to the juveniles who are becoming adults?
I guess that's for you.
So in regards to the school system, I'm not able to answer that question, but I will tell you that when there are multiple individuals who are stopped in a vehicle in particular, everyone is charged.
So you wouldn't consider that overcharging, right?
That is overcharging, yes.
That would be overcharging?
Yes,
Well, how
everyone
would you
is charging
determine
cars.
whose ghost gun that is? If it's 4 people in the car, a ghost gun is underneath the passenger seat, nobody claims that it's their gun. So would you just charge the driver and let the other 3 people go anonymous, or how do you figure out who you're gonna charge? I mean, because you were big on overcharging, so I'm trying to get to the bottom of that.
So if there are several individuals I'll give an example of what is often the case. You have 4 individuals in a car, and something is found concealed in a bag, and everyone is charged in the car. So it can be a purse, it could be a backpack with the name tag Natasha Dartig on it, but if we are all in the car, we are all charged. That is what is occurring every day.
Right, do you consider that overcharging?
Yes, that is overcharging, yes, because what will happen is that the other persons in the car will most likely the cases will be dismissed because they're not able to prove that in fact they were in possession of whatever was found in the bag.
So potentially every case will be dismissed, all 4, the driver and all the passengers?
If the state is unable to meet its burden beyond a reasonable doubt, that is the law, yes.
Yes, okay, that's good. And then so in reference to when are these concepts being taught? In the school, so you don't know?
I was gonna ask the secretary to answer that because they're actually being taught if a child is in juvenile custody and they get an education.
Yeah, it's taught once they're in custody, right? Well, my question is, when is it taught before you have this contact with law enforcement? When do you get this knowledge of good versus evil?
That's a very good point. Thank you, Dr. Conway.
All right, Delegate Congolo, thank you for being patient.
Thank you, Madam Chair. So I just wanted a clarification, and I want to just put it plainly. I believe you said that 80% of the Black youth that you service are also low income?
In terms of clients of the Office of the Public Defender, you have to be indigent in order to qualify for our services. So if you do not qualify as indigent, you would not be represented by the Office of the Public Defender.
I see. Okay, so what are the percentage of Black youth who are, I don't know, upper middle class, maybe middle class, where their families can afford a high-end attorney? Do you find that they also are stuck in that bottleneck in the adult system?
I do not have the statistic. I don't know if my colleagues do.
Okay. I'd be interested in knowing kind of find out the demographic. Is it, we're looking at race, looking at it through a racial lens, but I'd be interested in seeing it through a socioeconomic lens. So, thank you.
Thank you. Delegate Stinnett.
Thank you, Madam Chair. To the Secretary, I just want to get something so I can kind of understand a little bit better. In terms of youth that are being sent out of state, is this, I know the panel or the group that we had prior was saying that the group that are out of state or the youth that are out of state is because of either the institutional organizations are rejecting them for whatever reason, or are they being sent out of state because of the type of crime that they've committed, or I'm just sort of unclear with the reason why that they're being sent out of state.
Yeah, over the last decade, the department has dramatically decreased the number of young people who are served in residential placements out of state. When I started at the department 15 years ago, we had over 100 kids out of state. Today we have under 10. And the reason why we have under 10 is because we've been able to build a better continuum of services here in Maryland. But that continuum doesn't hit all the diverse needs sometimes that our young people present with. Sometimes their needs are so acute and so specific that we want to make sure we get them to the right placement. And sometimes that does require an out-of-state placement to have a place that meets the exact needs of that young person. It may be because of cognitive limitations. It may be because of significant behavioral health needs. reason may be because of the nature of the offense, and sometimes a combination of all of that. But it is the rarity anymore when we have to do that. But we want to make sure that we're serving the young people in the best place for them. And I will send a young person out of state if that's the best place for them. It also has to be approved by the court.
Okay, so they're bringing, exhausting the possibility of staying here.
Yeah, we have to, by law, exhaust all the possibilities in state before we utilize an out-of-state placement.
Gotcha. Thank you, Secretary. Thank you, Madam Chair.
Delegate Woods.
Thank you, Madam Chair. I want to go back to the, when youth are transferred back to juvenile court after they've been in an adult court. I want to know if there are any comparative stats of how the statutory structure backfires. Like, are there any comparative stats that show from state to state where those comparatory structures backfire when that youth goes from the adult court back to juvenile court? And if you could also answer if it includes like the cost and all of that.
So I can give you some information on that, and if we need to dig a little deeper, we can definitely come and meet with you and talk about some additional studies. But I mean, there have been studies over the years that are completely consistent. The the CDC has said that transfer to adult court is associated with an average of 34% increase in violent recidivism. OJJDP, the Office of Juvenile Justice and Delinquency Prevention, has found that youth transferred to adult court have higher rates of rearrest, reoffending, and violent recidivism. The National Research Council at the National Academy of Sciences has found that transfer to adult court does not reduce crime and exposes you to conditions that increase the likelihood of reoffending. We've had other studies also from the Department of Justice that has found very similar findings, as well as other states who have been able to do longitudinal studies because long ago they corrected the rights of their systems that required a lot of young people to be charged in adult systems. I can also tell you, I have recidivism information. We track recidivism almost every possible way you could look at it. We look at rearrest, reconviction, and reincarceration. We look at it 6, 12, 24, and 36-month timeframes. Looking at the 12-month follow-up for young people who are in the juvenile system, who were committed to residential treatment, the reconviction rate is 18.5%. So that means 82% are not reoffending within a year. And for youth who started their cases in the adult system and go to residential treatment, only 12.7 recidivate in a 12-month time period. And that's the reconviction, whether or not they were actually found guilty of an offense. When we look at probation, we see very similar numbers. Those served on probations, we have a 17% recidivism rate after a 12-month follow-up for a reconviction, and a reconviction rate for youth who started their cases in adult court at 15.4%.
Thank you, Madam Chair. Excuse me, Madam Secretary. Thank you, Madam Chair.
Thank you. All right, this concludes our first favorable panel. We have several others. So I'm going to call the second panel. Heather Warnken, Olivia Nagel, Reverend Dr. Marlon Tillman, Lydia Watts, and Kelly Quinn. It's only 5. Okay, we have everyone. Will we start from this side, please, and go this way? Thank you.
Certainly. Good afternoon, Vice Chair, members of the committee. My name is Lydia Watts, and I am the Executive Director of the Rebuild, Overcome, and Rise Center, or ROAR, at the University of Maryland, Baltimore. I am here in support of HB 409. The views I share are my own, offered in my professional capacity. ROAR provides wraparound services to survivors of serious crime in Baltimore City, including sexual crimes. Since 2019, we have served more than 900 survivors of homicides, shootings, sexual assault, and intimate partner violence. I personally have spent nearly 30 years as a licensed attorney representing survivors in both criminal and civil systems. I want to be clear, automatically charging young people as adults is not an evidence-based response to harm. Youth who cause serious harm have almost always experienced significant trauma themselves, trauma that adult prosecution does not address. A few years ago, Roar worked with a mother whose teenage son was seriously injured in a shooting. While she was navigating her own trauma, she told us she did not want another young person's life destroyed through adult incarceration. What she wanted was safety, accountability, proportional accountability, and real intervention so that no other family would experience what hers did. That perspective is far more common than you may assume. In my experience, well over 90% of the survivors I have represented over the last 30 years were not asking for harsher punishments. National research supports this is true for a large majority of victims. Many, particularly in communities of color, are acutely aware of the harm caused by overcriminalization and mass incarceration. Survivors consistently tell us they need safety, stability, and healing. That means safe housing, long-term counseling, legal assistance, employment support, and meaningful choice in how their harm is addressed, not automatically charging with the harshest possible sentence. I urge a favorable report on HB 409.
All right, thank you. Next.
Thank you, Madam Chair, members of the committee. My name is Olivia Noggle. I'm the Youth Justice Campaign Strategist with the Sentencing Project, and we're also a member of the Maryland Youth Justice Coalition. I'm here today in support of HB 409, the Youth Charging Reform Act. I've submitted written testimony as well, and want to focus my remarks here on Maryland being a national outlier when it comes to its practice of automatically charging youth as if they were adults. Compared to other states, Maryland has an unusually long list of 33 charges that start in adult court. And with such a long list of charges, it's not surprising that per capita, Maryland automatically transfers more of its youth into adult court than any other state except for one, which is Alabama. Overwhelmingly, they're youth of color. By comparison, in neighboring Virginia, there are just 5 charges, 4 of which are specific murder charges that automatically start youth in adult court, and they do not allow youth under 16 years old to start their cases in adult court under any circumstance. Additionally, there are 6 states that require all of their cases involving youth to start in juvenile court, with the juvenile court judge retaining discretion over whether the youth is waived to adult court. And since the year 2000, half of the states have narrowed or eliminated automatic pathways to adult court. Maryland should follow suit and pass this bill this year. We urge a favorable report. Thank you.
Thank you. Next.
Good afternoon, Madam Chair, Judicial Committee, Reverend Dr. Marlon Tillman, representing Bridge Maryland Incorporated and the Maryland Youth Justice Steering Committee. Eleanor Roosevelt once said that small minds talk about people, average minds talks about events, but great minds talks about ideas, ideals. There is one ideal that I want to lift up today, and that is the golden rule. Do unto others as you would have them do unto you. These are children. Children should be treated like children. The moment that we adultify them in order to justify how they are incarcerated, we have done them an injustice. Children should be, this bill does one thing that is greatly appreciated by us, and that is this. It simply says that things start in the juvenile system where judge and can see the court, can see this child first for who they are. And then it can be waived up as necessary as the courts are treated. At the end of the day, well, I want you to ask yourselves as you listen to the opponents, are they talking about people? Are they talking about events? Are they talking about ideals that they themselves will want to appreciate, and the fact that they also want to have that same golden rule applied to them? And so at the end of the day, will you please vote favorable for HB 409? Because it's been 14 years. In the words of Sam Cooke, it's been a long time coming.
Thank you, sir. You may go ahead.
Good afternoon, members of the committee. Heather Warnken from the Center for Criminal Justice Reform at the University of Baltimore School of Law, also a member of the Youth Justice Coalition. There's so much to say about the importance of this bill, but I want to use my time to address a frequent claim from the opposition that DJS does not have sufficient resources or capacity to appropriately respond to youth currently charged as adults, so therefore the status quo is preferable. The research and data are clear. It is not. As detailed in our written testimony, youth charged as adults faced heightened exposure to sexual violence, physical violence, and prolonged isolation. This does not just compound their trauma, it increases their likelihood of reoffending. Youth prosecuted in adult court are 34% more likely to reoffend and commit more serious offenses than youth served in the juvenile system. Nearly all system-involved youth have significant trauma histories. Yet in the adult system, we respond by adding more trauma, violence, uncertainty, delays, conditions demonstrably worse in DPSCS custody than DJS. As most probably already know from the steady stream of harrowing headlines and yesterday's DPSCS budget hearings, the resources and conditions offered in the adult system are grim. Assaults, homicides, and suicides in DPSCS custody have risen sharply. At the DPSCS-run Youth Detention Center, where youth charged as adults are held, this is particularly stark. 80% of youth charged as adults are placed in solitary at some point, and over 80% report abuse from staff or other incarcerated individuals. Due to our correctional staffing crisis, this is only getting worse, especially for our most vulnerable populations. The newly established Office of the Ombudsman is flooded with complaints and nowhere near at capacity to respond to them. DPSCS is facing numerous lawsuits over inadequate medical and mental health care, crumbling infrastructure, overuse of solitary, and this astounding increase in violence. DJS is already serving the majority of these children anyway. DPSCS is not. I truly struggle to understand the defense of the status quo through this lens.
Thank you so much.
Good afternoon, Madam Chair and members of the House Judiciary Committee. I'm Kelly Quinn. I'm also with the Maryland Youth Justice Coalition. I'm a District 46 voter, and I'm the Managing Director of the Choice Program at UMBC. Respectfully, we urge you to issue a favorable report on House Bill 409. Since 1988, Choice has served more than 27,000 young people across the state of Maryland. We believe that young people are best served in community. Every day we see what is possible when young people are met with high expectations and high support. We also see the harm that when children are pushed into the adult system. My colleagues are telling you about the facts, the figures, and the research. I want to tell you about Kelly, a participant in our program. When Kelly first came to us, she described herself as persistent, patient, understanding, and caring. She loves the electric guitar, art, and nature. She came to this very room last year and met Delegate Embry and Delegate Clippinger on an advocacy night. She is thoughtful, she is creative, she is a child. But because of Maryland's auto-charging laws, she was sent into the adult system. There she endured solitary confinement. She became so despondent that she wanted to die by suicide. She was served finger food because the staff was concerned that if she had cutlery, she would harm herself. She spent time in Spring Grove, and instead of rehabilitation, she experienced isolation and trauma. Kelly's story is not an outlier, and what I know is that policies born from fear and the myth of the super predator continue to fall hardest on Black children. Today, Kelly is in community, she has a job, and I hope she's playing her electric guitar. 409 restores discretion where the whole child, not just the charge, may be evaluated. Thank you.
Thank you. I don't see any questions for this panel, so I'm going to conclude this panel and go to the next favorable panel. I'm going to call Nick Maroney, John McCarthy, Allison Healy, Philip Caroon, and James Dold. And we'll have Monique Dixon on deck. Thank you.
Still.
You recall, Mr. McCarthy. What, are you favorable?
No.
Well, we don't need the unfavorables yet. McCarthy is unfavorable?
Yes.
He is listed as favorable, but it's okay.
And I'm unfavorable. I was moved to favorable for the other bill.
What's your name?
Allison Haley.
I called your name.
Yeah, I'm unfavorable.
I thought you just changed.
No, earlier I changed for the other bill, 4440.
Okay.
It's 449.
Okay, let's do this again. Nick Maroney?
Yes, Chair.
And Monique Dixon is virtual, Phil Caroon, James Dole, and Christine DeFore. Thank you so much. You may proceed. You want to start from this end, sir?
Oh, sure. James Dole, for the record, representing Human Rights for Kids. I want to start my testimony by first addressing some of the arguments that you're going to hear from opponents in just a little while. The first argument that prosecutors will sometimes put forward as to why they want to maintain the status quo is that if we change the auto-charging statute, essentially we'll open it up to older adults recruiting kids into committing crimes. What I want to say to that specifically is that when those things happen, we have a word for that. It's called human trafficking. Those adults should be prosecuted, not the children who are the targets of those adults trying to take advantage of them. The second things that prosecutors are going to say is that they only use auto-charging for the most serious violent crimes. Yet 50% of all of the cases that we know of, right, that are charged as adults are for misdemeanor handgun possession. I want to make one quick point on this. Maryland is the only state in the country that automatically charges misdemeanor handgun possession in adult court. The only state. The third point I want to highlight is that opponents will say, well, that we want to auto-charge because we want courts and judges making the determination on pretrial release, not the Department of Juvenile Services, right? They'll say it's a public safety concern. But DJS actually has adopted a memo, and I think the Secretary could also speak to this, where if a crime of violence is committed or a handgun possession, they do not release those children. They wait till the next day when the court can make that determination. So that's a non-point from the opposition. I also just want to highlight real quickly what we're talking about here, right? Almost 1,000 cases were brought up and auto-charged last year alone, right? The vast majority of those, 56%, were sent back down to juvenile court. Only 238, or 25% of those cases, remained in the adult system. Now, here's the most important part of this, all right? Only 5% of that 1,000 cases ended up with an adult prison sentence. 47 kids out of 1,000, which begs the question, what the hell are we doing? Why are we sending 1,000 kids to the adult system when only 47 are getting adult prison sentences?
Could you please wrap it up, please?
Yes, ma'am. It makes absolutely no sense. The reason it's important, number one, kids are being harmed. They're being placed in adult jails, as we mentioned. But second, it's inhibiting DJS's ability to provide timely and effective services to these youth. That's why this bill is so important. With that, I would strongly urge a favorable report on House Bill 409.
Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Christine Dufour. I'm a criminal defense attorney. I've been both with the Public Defender's Office. I'm now in private practice on the Eastern Shore for a larger Montgomery County firm. I represented juveniles as a public defender. I represent some juveniles as a private attorney. What I can tell the court, what I can tell this committee is I've been to the juvenile facilities, I've been to all the adult facilities on the Eastern Shore, as well as in Montgomery County. There is no reason a juvenile should, barring very specific circumstances, be in an adult jail. There is the issue of the sight and sound violations, and it's very difficult for facilities to separate and follow that policy. So as a result, the juveniles are typically held in isolation. I've had juveniles put in jackets because they're threatened to kill themselves because of their situation. We'd ask that this committee, I urge a favorable report. I think as Maryland Criminal Defense Attorneys Association, we're about 420 members. Not all of us do juvenile law. However, we support not just what our members might support, but we support good and sound public policy, and I believe House Bill 409 is sound policy.
Mr. Carew?
Good afternoon. Acting Chair, members of the committee, Phil Caroom. I'm speaking today for Maryland Alliance for Justice Reform. It's a nonpartisan, all-volunteer group with about 2,000 individual members around the state and 50 churches and other organizations. not speaking officially for the court system. However, I would like to focus my testimony not repeating anything that I put in writing and not repeating things that other witnesses have said on one point, which I talked to you about as a former juvenile administrative judge and former juvenile prosecutor for many years. That is the argument that somehow changing this law would cause state's attorney's offices to be overwhelmed. And in the fiscal and policy note, it suggests they would have to, in 8 counties, who knows why the other 16 are left out, that they would have to hire 59 new people. The kindest thing I can say about that allegation is I believe it's a red herring and perhaps a budget mechanism to increase funding on a local level. The reality is that if this law were adopted, you would have exactly the same number of cases. You would have exactly the same number of waiver hearings, waiver or reverse waiver, as before. It would just change the proportion which are heard in juvenile court and the proportion that are heard in adult court. And the preparations of state's attorneys for these hearings would be, in essence, identical. If anything, they would have less preparation to do for the juvenile hearings because there's a presumption that the offense occurred and the juvenile was involved in it, which is not present on the adult side. So again, for the reasons I've stated before in writing, and for this reason, I urge a favorable report on 409.
Chair Davis, honorable members of the committee, my name is Nick Maroney. I'm a retired Maryland State employee who worked to constructively change conditions in the juvenile justice system from 2007 until 2025. I fully support the bill. The legislative fix is, in my view, essential to put a stop to the chronic glut of young people charged as adults and held in juvenile services detention centers and in other jails for long periods of time, up to 2 years. Children and young people, poor and without political clout, are easy to forget about when targeted and denied their right to a proper hearing in a court before being locked up for months or even a year or even more. Some people blame the youth themselves who failed to thrive after being cycled through this process. A few states' attorneys blame the Department of Juvenile Services, while some even argue that the adult correctional system would better serve young people. I hope you see that argument as both ridiculous and tragic. While it is true DJS offers flawed services, corrections offers no substantial services for young people. While some prosecutors may believe it too politically risky to not recommend secure detention for young people as soon as they level charges against them, it would be more just not to do so. The Maryland justice system currently incentivizes young people who are locked up on an automatic charge to accept a plea bargain to end what can be an indefinite period in a youth or adult jail. You can change all of this. You can make the system work better for everyone. You can refuse to accept the status quo that allows people to be condemned to an adult or juvenile jail without any meaningful chance to exercise their due process rights. After this bill passes into law, young people accused of the most serious of crimes will still be automatically prosecuted in adult criminal court. So too will other young people, because judges will hear prosecutors' arguments and accede to some of those arguments. But there will be no more mass locking up of young people and throwing away the key before they have a meaningful opportunity to be heard in court. And so I wholeheartedly support this bill. I urge this justice-informed committee to give this important bill a favorable report, and I'm sure that the members of the General Assembly will overwhelmingly support this modest but vital proposal. Thank you.
Thank you, sir. On this panel, the last person is Monique Dixon.
Good afternoon, everyone. I'm Monique Dixon, Executive Director of the Gibson Bank Center for Race and the Law at Maryland Carey Law. The center is also a member of the Maryland Youth Justice Coalition. We appreciate the opportunity to provide both written and oral testimony in support of House Bill 409, which in our view is a step in the right direction toward ending Maryland's inefficient, racially disproportionate, and harmful practice of automatically charging children as adults. National research shows that Black children are overrepresented in both the youth and adult criminal legal systems, in part because they are often seen by decision makers as being older and less innocent than their white peers. This adultification of Black children leads the general public and decision makers to unfairly fear and criminalize Black children and youth. House Bill 409 could significantly impact all children, especially Black children who are charged as adults, by beginning more cases in the youth court system where they would have access to age-appropriate treatment and services that are largely unavailable to them in the adult criminal legal system. In our view, all cases involving children should begin in a system that understands children are different from adults and that they are more responsive to treatment, rehabilitation, and accountability systems. For these reasons, we respectfully ask that you issue a favorable report for House Bill 409. Thank you.
Thank you. Questions for this panel? I'm going to start with Delegate Moreno.
Thank you, Acting Madam Chair. This question's for James Dold. When it comes to prosecuting 14 and 15-year-olds as adults, can you tell us which states start those cases in juvenile court, and including homicide-related offenses?
Absolutely, Delegate. Thank you so much for the question. James Dole for the record. My colleague from the Sentencing Project earlier referenced Alabama as the only other state that charges more youth as adults in their system. What's interesting about Alabama is that they don't do that for 14 and 15-year-olds. All of those cases, regardless of offense, start in juvenile court. I've routinely said, and I've challenged this body in the past, to always be as progressive as some of the most conservative states in the South. And if Alabama is doing it, then certainly Maryland can do it. But there's other states as well. Alaska, California, which by the way is the size of a large country, they actually don't charge any kids under 16 as adults, ever. Not discretionary transfer, not mandatory bind over, nothing. All kids under 16 in California stay in the juvenile system. And by the way, they have record low juvenile crime, just for the record there. But we also have Hawaii, Illinois, Indiana, Iowa, Colorado, Maine, Minnesota, Missouri, New Hampshire, Nevada, Oregon, Ohio, the progressive bastion of Texas, and South Dakota, and South Carolina, and Utah, and Washington. All of those states automatically start children under the age of 16, 14 and 15-year-olds or younger in the juvenile system. Thank you very much for the question.
And then I had one last question, and when you were saying all those states, it almost sounded like the Johnny Cash song. I've been everywhere, man. Anybody? Anyways, so it's been mentioned that 50% of all cases that are automatically charged in adult court are for misdemeanor gun possession. Are there any other states that automatically charge children in adult court for the simple gun possession charges?
There are none.
Okay, thank you.
Very good.
Actually, best to answer my question that I asked the previous panel. So you mentioned that you are a public defender as well as a private attorney.
I was a public defender. 4 years ago, I left the agency, and I was both a public defender and in private practice many years ago in Montgomery County. When I moved to the Eastern Shore, I went back to practicing with the public defender's office after taking a break to raise children. And I left 4 years ago, and I'm now in a private practice with a larger Montgomery County firm. I cover the Eastern Shore for that.
Okay, so your private practice, these are families that are paying you for your services?
Yes, I've only had in the 4 years that I can think of privately 2 juvenile cases. One was litigated in court, and it had to do with a sexual offense. The other that I can think of, it was most recently, and it was not a sexual offense. I think it was a drug case. I can't remember for sure, but 2 families have hired me.
Okay, I see. So then I guess you probably won't be able to answer my question because I'm just looking for some data because the young lady on the screen virtually mentioned that this disenfranchises Black youth, and then a gentleman mentioned that this you're seeing more of these cases for families who are poor or without political clout. So I'm looking at the socioeconomic piece. I really want to know if you see those same outcomes for kids that pay you for your services privately, or maybe your colleagues. Do you see that those Black youth they don't get stuck in this adult bottleneck in the adult court system?
So I can answer you this. I know the public defender statute guarantees representation to all youth, no matter what their socioeconomic status is. That's an outlier from what they are permitted, unless I'm correct that it's changed, but my understanding was the statute, we were able to, as public defenders, because there are some families who might have money, but not mad at, son Johnny for being accused of doing XYZ, and mom and dad aren't going to pay. So youth have an absolute right to have representation by the public defenders, despite what their family income is. The couple of cases I had were children with no prior record whatsoever, very supportive families, and they were not detained. But their charges necessarily did not warrant detention. The situation with the sexual assault case was a situation where children who were dating and then fell out of favor. And so it was a he said, she said.
Okay. All right.
I hope that answers you in some regard.
Well, it did. I mean, I just, because the previous panel, I had learned that I think the young lady said that the youth who go through the public defender's office are determined indigent. So that led me to believe that that meant that you had to be under a certain income level to qualify for services through the Office of Public Defender. So,
and I know Madam Public Defender is still here, so, but when I was on the government relations team for the Office of the Public Defender and we drilled down on our statute for the eligibility issues that arose years ago, it was my understanding that it was an outlier for juveniles, that they did not have to show they were indigent, for the very reason that I said, that if mom and dad or grandma doesn't want to pay, how's, a 13-year-old going to pay for representation?
That's a tiny percentage of kids whose family says we're not hiring an attorney.
Okay, but if they can pay, those kids don't necessarily get detained, or are you seeing that they go?
I would say anecdotally that they have much better outcomes.
Right.
But I've never seen a study, and I myself have not compiled a study to say percentage-wise how much, but just anecdotally, yes, they do.
Okay, all right, that's what I think it's unfair for any child, no matter your background or income. But I just want to just kind of make some sort of differentiation between, is this about race or money? So that was where I was going with it. Or it could be a combination, but that's what I wanted to look at.
If you're from a wealthy family, when you show up in court, you're already in drug treatment, you're already in counseling. They've already, taken 6 steps to make sure this never happens again. So they're very well prepared, unlike the kids who have only come to see the public defender once.
Okay. All right. Thank you.
Thank you. Delegate Cardin.
Madam Chair, thank you all very much for your very compelling expertise and testimony. Really appreciate it. This is for Ms. DeFore. And by the way, what you just said, because I have represented some of these youth as a private attorney, and that's in fact the case. We try and prepare them as best as we can so that we can avoid some of the issues that we're dealing with. This is for Ms. DeFore, as I respect your opinion very much from your years of experience. What you and some of your other panelists talked about really was about incarceration, not necessarily about charging and going through the adult system, but being incarcerated among adults and the negative impacts. Is this, I understand that this bill could have an impact on that, but there could be a separate legislation that requires detainment to not be anywhere near adults. Isn't that the case? I mean, not necessarily related to this. I mean, it could be related to this, but it's not necessarily this.
It's my understanding that federal law requires sight and sound separation. I believe Ms. Tolentino addressed that earlier.
Right, but they're not. But right now, it's not happening as well as it could. Right.
As Delegate Taylor addressed, that there are some inefficiencies in how children are treated in adult jails. Yes.
So it's not necessarily being tried as adults, but how they're being treated in adult jails.
Yes, that's a component here that would alleviate if you have less children charged as adults exposed to the possibility of being held in adult detention centers, then you'll have less of a percentage of children who might.
And being held in adult detention for 6 to 12 or more months.
Okay, thank you.
Can I just add something to that, Delegate Cardin? So Corrections runs a center for kids who are charged, who cannot be held in the juvenile detention centers because of the nature of the seriousness of the charge. And so they are not, let's say, mixed in with adult, quote unquote, offenders. At the same time, in that youth center in Baltimore, the staff use bear spray on the kids all the time. If a kid has a mental health crisis, that kid is stripped and put in a paper gown and put in their own room for an indeterminate amount of time until something gets sorted out, et cetera. So just because kids are held in a place that only houses other kids doesn't in any way guarantee that it's going to be fitting or just, or that the conditions are going to be what we would hope.
That's not what this bill is about, though.
It's not, but also Baltimore County Detention Center for Adults, they are in accord with sight and sound mandates by keeping kids charged and adults in a cell for 22 hours, 23 hours.
We know, we have a major problem.
Okay.
We know about that. Thank you.
Delegate
You're right.
Cardin.
You're 100% right.
May I add to that just real?
That's for the chair to decide.
All right. Are there any other questions? Thank you all for being here. We're going to call the next panel, the next favorable panel.
Thank you.
Kara Annenson, Zainab Chaudhry, Terry Speaks, Erica Shavaria, and Kate Rudy. How many is that? 1, 2, 3, 4, 5. And Aaron Seegers. Is that 6? 5. 1, 2, 3, 4, 5, 6. Okay, I want to get a full panel here. Who don't we have? Could you identify yourself, please?
Excuse me. Terry Speaks. Terry Speaks.
Okay.
I'm Erin Seegears.
Okay.
Kate Rudy. Zainab Chaudhry.
Okay, so Karen is not here? Kara is not here? Okay. That's 4. Let's get another person. Is Ms. Palia still going to speak? Yes, you can come up. Nicole. All right, let's start from this side.
Good afternoon. My name is Terry Speaks. I'm here to support Bill 409. Thank you, Chair Bartlett and Vice Chair and members of the committee. I am here today to offer testimony in strong support of House Bill 409. I strongly oppose the practice of automating charging youth as adults in the state of Maryland. I come before you not just as an advocate, but as someone who lived through this experience firsthand. At the age of 16, I was tried as an adult. I was still a child, emotionally, mentally, and developmentally. Yet I was forced into an adult legal system that was never designed to protect or rehabilitate youth. In Maryland, the majority of youth who are initially charged as adults are eventually sent back to juvenile court. This reality alone shows that the system recognizes that many of these young people should never have been charged as adults in the first place. However, by the time that correction is made, the damage has already been done. Being placed in an adult court facility causes serious and lasting trauma. Adult prisons are not built for children. They expose youth to fear, violence, psychological harm that stays with them long after their case ends. No one truly understands the weight of that trauma unless they have lived it. I did, and it follows you into adulthood, impacting education, employment, mental health, and an ability to rebuild your life. Children deserve rehabilitation, guidance, support, not adult punishment. Automatically charging youth as an adult does not improve public safety. It only increases harm, deepens trauma, and successful reentry to society. That's the last thing I'm gonna say. Thank you. all the trauma and the different things that I've suffered in my life have led me on the course of being an advocate within my community. I wear this pen that y'all wear because someday I plan to sit where you sit, right? And I say a lot of children don't get that opportunity, so I urge you to give this bill a favorable report. Thank you.
Thank you, sir. Where do you live? I'm sorry. Sorry.
District 41.
Let me curse on my district.
Okay, you can go ahead, please.
Good afternoon, Chair and members of the committee. My name is Erin Seegers, and I'm a supervising attorney in the Juvenile Division of the Maryland Office of the Public Defender in Baltimore City. So I have the immense privilege of representing youth, both children charged in juvenile court and, unfortunately, children charged in adult court. I've done this work both in Baltimore City and in Anne Arundel County. I do want to start off by clarifying a couple of things. For one, as the Office of the Public Defender, we represent indigent people. When it comes to juvenile cases, we look at the client, which is a child. So we look at if a child would qualify for our services. As you can assume, children do not have money, so that is why we, by default, represent the vast majority of cases unless their parents are able to pay for the representation. I also want to hit on briefly this issue of the paneling that has come up. This is and the idea that children are waiting long amounts of time to get a panel attorney. This issue, from my understanding, is mostly concentrated in Baltimore City, and I actually personally handled the paneling list of Baltimore City Juvenile Court, and I'm happy to say that we currently do not have any children waiting for a panel attorney, so there is not an issue with that currently. Finally, I want to talk about the scope of this bill. As has been noted, it is not an end to the automatic charging of kids as adults, but it is a limitation. So it only actually hits on a few different charges, in addition to the charges where a child could receive a life sentence. There's a number of additional ones, too, that are completely untouched by this bill. That does include second-degree rape that came up earlier. So I do want to be clear that this is a pretty modest step forward and does not end all charges. In my last 15 seconds, I would like to say I would love to be able to share stories of not only the horrors that we see when children are in the adult system, but the true success stories and the joys that I see on a regular basis when children are in the juvenile system and do get the healing and the help that they deserve and that only the juvenile system can provide. So I'd love to meet with you all to discuss those.
Thank you. Next.
Hello, Madam Chair, members of the committee. Thank you for your leadership, and particularly, Madam Chair, thank you for sponsoring this bill. My name is Kate Rudy. I am a member of Social Work Advocates for Social Change. We're a coalition of Master of Social Work students at the University of Maryland. I've also worked on juvenile justice policy and law here in Maryland at the Administrative Office of the Courts about 15 years ago, and we were looking at these issues, and I really hope that we can make changes. Now I also worked at the International Association of Chiefs of Police, managing a juvenile justice project with law enforcement, and I hope that we will see an increasing number of law enforcement leaders and prosecutors backing these changes. The Social Work Advocates for Social Change, we urge favorable report on HB 409. The Social Work Code of Ethics calls for interventions across the board, including in the criminal and juvenile justice system, that are fair, proportionate, and developmentally appropriate. And as we're hearing, the current law and practice in Maryland is not fair, it's not proportionate, and it is not developmentally appropriate. You've heard testimony of the huge racial disparities that Black youth are 7 times more likely, with the same offenses to be charged in the adult system compared to white youth. In terms of proportionate, we've heard that there are many months waits to hear a trial for transfer to the juvenile system, even though 3/4 of those cases will end up back in the juvenile system. And of course, the sight and sound protections of federal law that are supposed to protect youth are leading to huge use of solitary confinement. With social workers know there are long-term, lifelong mental health consequences of that. And in terms of developmentally appropriate responses, the educational disruptions, among many other things that come from this, also can have lifelong effects on youth and huge rates of increased violent crime when youth do not complete school. Thank you very much. I urge passage, favorable report on the bill. Thank you.
You may proceed.
Good afternoon, Chair Bartlett, members of the committee. My name is Zainab Chaudhry. I'm the director for CARE's office in Maryland. CARE is a Council on American Islamic Relations. We're the nation's largest Muslim civil rights and advocacy organization. And through our work in advocating for social justice issues, juvenile justice reform has been a top priority for our organization for many years now. As someone who was born and raised in Baltimore City and who has seen the impact of our broken system on young people in Baltimore through the educational system as well as in broader society, this bill is a very critical way to reform our system and make sure that we are brought up to par with many of our other states across the country. The fact that we are in 2026 and Maryland is still so lagging far behind when it comes to basic reforms is shameful. It's an indictment of the fact that our system is broken and there are meaningful reforms that need to happen, and this bill is just one example of that. This bill, as mentioned, simply restores common sense. It allows youth cases to start, as mentioned, in juvenile court, where a judge can look at each child, not adults, not people, but children in many cases, as individuals and decide whether adult court is truly necessary. This does not eliminate accountability, as it has been mentioned many times. It ensures accountability. It is fair, thoughtful, and based on real circumstances. You have my testimony in front of you. I don't want to waste your time with going through it verbatim, but I do want to encourage you just to keep those children who are directly impacted by this issue in your mind as you decide whether or not to vote in favor of this legislation. Thank you very much for your consideration.
Thank you.
Good afternoon, Vice Chair Davis and members of the committee. My name is Nicole Palia, and I'm here to testify in support of House Bill 409. I've been an attorney with the Public Defender's Office for nearly 20 years. My career started in Baltimore City Juvenile Division, and I am now the Deputy District Public Defender for the Upper Shore, which includes Caroline, Cecil, Kent, Talbot, and Queen Anne's counties. I represent children in juvenile court and adult criminal transfer proceedings through all 5 of these counties. What I can tell you is that the current system for handling youth charged as adult leads to unequal treatment across Maryland. While all initially processed in in adult jails, many remain there despite the orders to remove them. In smaller jurisdictions such as ours, jails cannot accommodate this federal sight and sound restrictions that you have heard from. What that results in is children being held in isolation, usually 23 hours a day, or they are transferred to a youth wing in other detention centers where they can still hear and see the adults, exposing them to threats and potential abuse, all while not getting education or any form of treatment. I would like to address today what I see as some of the top misconstrued and misstated points by the opposition to this bill. I cannot address all of them, so I welcome your questions following my testimony. First, the serious crimes and cases the opposition routinely uses as examples refer to offenses that are simply not applicable to this bill. The processing concerns raised by the opposition do not align with the vast majority of transfer or waiver cases by way of practice or statute. Charging youth as adults actually increases recidivism and erodes public safety, not the juvenile system, which leads to reduction in crime and recidivism. Every offense that can currently be charged in the adult system can also be petitioned in the juvenile system, which is designed to encompass all youth up to the age of 21. I'd like to emphasize that supporters of this bill are asking for 11 charges to no longer be automatically charged in adult court. We are not asking to take away the ability from the state to be able to prove and ask for those to be prosecuted in adult court. For these reasons, I urge this committee issue a favorable report on House Bill 409.
Thank you. Thank you so much. I believe, is Michael Parsons available virtually? Okay, no Michael Parsons. Any questions for this panel? Wait, I have to make an announcement first. Colleagues, to remind you that the hopper is closing at 5. You gotta get your bills in. All right. All right, everybody okay? I'd hate to lose you all at once. All right, questions? Yes, Delegate McComas.
The gentleman, I didn't catch your name, but obviously you're the gentleman with the blue suit. You were in, well, what would you do to change the way we're doing it right now? And assuming that this would not pass, what do you think is most important that needs to get changed for the system to be better for the kids so that they don't have such an adverse experience?
One, we need to show some empathy because at the end of the day, I don't have children, but those of y'all do have children. So let's just say hypothetically, right? I would want my child, let's just say, and we're not talking about the most serious charges, right? We're talking about, let's just say, handcuff possession. And I know that my child went through some things. I would want my child to be housed around children. I mean that not because I'm supporting this bill. I went through this. I lived this. And because I lived this, my whole trajectory of my life changed when I was housed around adults. I used drugs. I suffered mental health. I didn't change my mindset until my mother OD'd from fentanyl. And I'm being honest with you, right? And this led me to work for a great organization, Out for Justice, that helped me change my perspective. My first time ever coming to Annapolis was last year. I'm in a community, I'm talking to people. So it's easy for people to sit back and say, well, this child did this, or this child should do this. But at the end of the day, they are children, their mindset. When I was around them grown men, I seen things, heard things, experienced things that I wouldn't want for no adult to go through, let alone a child. So I'm saying, we're not saying that these children will get off because of this bill. We're saying they should start there. And if a judge or the prosecutor can prove that these children should be charged as an adult, then so be it. But before you give them an opportunity, we're supposed to live in the greatest country in the world, right? And if we don't have empathy for the least of us, children, we can get into the race and the economic aspect of it, but they are children regardless. At the end of the day, I don't care what background. Unfortunately, the majority of the children that suffer is black and brown children, but children in general need to have a fighting chance. So that's why every day I get up at 5:30 in the morning and I do what I have to do. That's why I come out here, testify on these bills, and support the legislation that's gonna give every child a fighting chance. And I think it's a good bill. It's not gonna solve all, but we gotta start somewhere.
Thanks, sir.
Yes, ma'am.
Okay, I have a question for Ms. Palia.
Yes.
I'm going to ask Delegate Congolo's question. You work on the Upper Shore.
Yes.
And do you see an economic component to how kids are being treated?
So what I will say is I absolutely do. I see in all of the 5 counties that I go to, it is unusual to see anybody who is able to afford private counsel to go through the process of a transfer, right? When you're talking about a process of a transfer, you're talking about evaluations, you're talking about a lot of time and energy that is dedicated to that, and the price that a private attorney will have to pay for that or charge for that is impossible for the clients who are being charged to meet. So while I will be honest with you that I cannot sit here and give you facts, that I cannot give you statistics, what I have seen in my almost 20 years of doing this is that there is absolutely an economic difference between the children who are charged as adults and those who are not.
Okay, thank you. I wish he was here to hear that. All right.
It's recorded.
Seeing no further questions for this panel, thank you for being here. We're going to call the next panel. The next panel is favorable with amendments. I'm going to call Davon Love, Anthony Brown, Arbery Luce, Edwards Lucy. She's online, so she can come. Oh, I'm sorry. Got him. I'm sorry, you're right. So it's just Davon Love and Arbery Edwards Lucy. You may proceed, sir.
The most highly circulated images and narratives of Black youth are related to notions of inherent criminality and notions that they lack moral turpitude. Whether it's pop culture, news media, these are narratives that are so ubiquitous that the belief that youth are prone to criminality are rational beliefs given the deluge of narratives that we see about this every day. So if we apply this to conversations about firearms, that's come up several times. And we think about in the Black community, we make jokes about how unresponsive law enforcement is when we ask them to come to our communities. Or when young people have negative experiences experiences with law enforcement. Even when they themselves want to make a complaint that they're treated like criminals, they have to prove they're not a criminal before they even heard. Or if you have a young person who's engaged in a cash economy, let's say they're selling candy, they get robbed. They don't have the money to sue people to get their money back. They often are engaged in activities, around other young people where they may feel afraid. I'm giving all of these examples to show that when that is the experience that a lot of our young people have, it is a rational decision for them, not condoning it, but a rational decision to say, I'm going to carry a firearm because the institutions in our society don't provide the recourse that is necessary when they are harmed. The reason why that's important is because dispelling the good guys, bad guys Hollywood frame when people think about crime and violence when we talk about our young people. So the way that racism and white supremacy makes the scripts that we have about Black youth, the way they impact this particular issue, is because when people hear a young person possessing a firearm, people are comfortable making a wide range of assumptions about who they are, the kind of young person they are, what their intent is. And what is often unfathomable is that that young person's carrying a firearm because they're afraid. Right? That they're carrying a firearm because they know other people have them. And so again, it's not that they're condoning it. What we're asking for with this bill is to not treat all young people based on those assumptions that people often jump to when they hear narratives about young people possessing firearms. To give them an opportunity to have a judge assess on a case-by-case basis what are the facts of the case, such that the kids that are afraid that are carrying firearms are not treated the same as those young people that actually are a problem for our community. Thank you.
Thank you. This is it for favorable with the amendments.
Oh, I'm sorry, I'm here.
Oh, I'm sorry, Ms. Lucy, I forgot. Davon, come back because we got questions. Mr. Love, I'm sorry. You may proceed, ma'am.
Thank you very much. My name is Aubrey Edwards-Luce. I'm the Executive Director for the Sarah and Neil Meyerhoff Center for Families, Children, and the Courts at the University of Baltimore School of Law. It's very difficult to stick to 2 minutes in the text of this bill when just over 2 months ago, I joined fellow advocates, parents, family members outside of the Baltimore Youth Detention Center on one of the coldest days of the winter, demanding that our government protect the body, minds, and humanity of the children who were being housed there. They had been charged as adults, and they were being subjected to cold temperatures that hindered their access to grow their minds and their bodies through education and exercise. This was the plight of the, quote, luckier, end quote, youth who had been charged as adults. At least they were in a facility for youth, unlike the majority of Maryland's youths who are subjected to essentially solitary confinement in adult facilities when they are charged as adults. Regardless of whether youth who are charged as adults are confined in youth facilities or adult facilities, sending youth to the adult criminal system is a serious action. It communicates, contrary to the research, that an adolescent is undeserving of the hope of rehabilitation that's found in the juvenile legal system. It tells teenagers that they're hardened criminals. It says to young people, even before they've had their day in court, that they need harsher, longer, more punitive punishment that's found in the adult system. A prolonged separation of teenage children from their families, and a prolonged separation between teenage parents and their very young children. Automatically charging youth is in direct contradiction to their well-being, our community's safety, and children's rights to family integrity. For these reasons, I ask for you to support HB 489 with amendments that would end automatic charging for all youth for all offenses. Thank you, and I'm available for any questions.
Thank you. I didn't mean to almost skip you. All right, questions. Delegate Conaway.
Thank you, Chair. Thank you, witnesses, for coming in and testify. Mr. Love, what is your agreement with the amendment? What amendment are you?
What the sister just mentioned, to end the practice entirety.
The end of practice.
So I think that all cases involving young people should start in the juvenile system. I know that's not what this bill is, but that's why I signed up as favorable with amendments.
Yeah, I was just asking you, what was your amendment?
Yes, sir.
And so you're saying that a lot of cases that involve the juveniles with firearms involve survival instincts, is that what you would say?
That it's a combination of survival instincts and many of the assumptions that people may have about why a person carries a firearm.
Okay, would you agree that survival instincts would trump other things that you might feel are questionable? In other words, if you feel that your survival is being threatened, that's something that you pretty much must respond to versus you just don't like your environment because of whatever is happening you don't have to really respond to that.
If I'm understanding you correctly, I think there are a range of responses that people might have to circumstances where they feel afraid or threatened. Possessing a firearm is one of those decisions that a person might make if they feel like they're in an environment where they feel like they need it.
Yes, okay. Thank you so very much.
Yes, sir.
Any further questions? All right, seeing none, that concludes our favorable with amendment panel, and now we're going to call the unfavorables. They're all gonna run in at the same time. We are calling Laura Wilt, Ivan Bates, Jamie Dykes, Allison Healy, and Brian DeGregory. Where'd they all go? We're going to get started. Please take your seat.
They're going again.
We have Bates, McCarthy, Dykes, Healy, Dykes, and Harvey. Dykes, Harvey?
Harvey's back there. Yep, I can sit back.
What's your name, ma'am?
I'm Laura Wilt.
What was your last name?
Wilt.
Wilt. I did call you. Please have a seat. Thank you.
You did. We'll let Ivan go first.
Mr. Harvey, do you want to come up also? We can squeeze you in because that would conclude the opposition panel.
Yeah.
The unfavorable panel, if you don't mind.
Squeeze you in.
What's your name, sir? Brian DeGregory. There goes my theory.
Sorry to tell you.
Sir, we're not going to try to put 7 of you up there. So next panel, okay? And that's the last one. I appreciate you. Patience. All right. Where do you want to start?
I'll go ahead and
They're
start.
pointing to you, sir.
Yes. May I?
Go ahead.
Good afternoon, Madam Vice Chair and members of the committee. My name is Ivan Bates. I'm the state's attorney for the Baltimore City, and I'm also the current president of Maryland States Attorneys Association. I'm here with a number of my elected colleagues as well. I'm here today in opposition of House Bill 409, but not because I don't believe in the intent of your bill, Madam Chair, who was here earlier, but rather because I believe in an extremely complex bill that, if passed now without addressing the countless levels of systemic deficiencies that currently exist within the juvenile system, will lead to an explosion of violent crime committed by juveniles. And while I sincerely believe in acting DJS Secretary Betsy Tolentino and her team are doing all they can to try and remedy these issues, the fact remains that there are far too many issues to be addressed within the current juvenile system to dump more cases on the lap and expect success in reforming the lives of these young men and women. Each one of these juvenile justice booklets, and everybody should have a copy of the juvenile justice booklet that my office prepared, we inform a number of readers, all readers, about the background of the juvenile justice system here in Maryland, specifically Baltimore City, its foundation and intended goals, while showcasing the kinds of deficiencies with the current system that we are living on a regular basis. Our real-life account of the system in this booklet, coupled with the ombudsman report that you received earlier as an indictment on our current juvenile system. It should give each of you pause before voting in favor of this legislation. My suggestion is that we take, and it's a suggestion of all 24 electeds, is there is no rush. Let's take the time, let's fix the system, and give our children what they really need, the support, the guidance, and the programming, while making sure that the constituents that put us here are also safe. It's funny, when I came here my first year, I was told, you know what, we need data. When I came the second year, you need to have data written. My third year, there's a booklet, and that booklet shows you specifically, don't know about every other jurisdiction, but in Baltimore City, we're failing the juvenile justice system, and let's no longer fail our children. Thank you.
Next, Ms. McCarthy.
Thank you very much. My name is John McCarthy. I'm the state's attorney for Montgomery County
Maryland. The thing that surprised me listening to the conversation that preceded us by the proponents.
In the mic.
Okay. What surprised me when I sat here for the last several hours is talking about the services that are being provided on a regular basis to our children. Well, let me tell you, that's not happening in Montgomery County. I will say that any child that is ordered into treatment, we are traditionally seeing delays of 3 to 4 months before that child's placed. I will also say to you that I think besides the fact they are placed, from our perspective, the treatment that is in fact provided ultimately is inadequate to those young people. I will say to you that there's also conversations that talk about how the juvenile justice system provides services up to age 21. I've looked at the numbers all the time. I can't find anybody that came out of Montgomery County at age 19 or 20 that's still receiving services. That's a fallacy. You can make that statement, but if you're not delivering services for that period of time, and I do believe some of these children have a constellation of needs that require longer services that are actually being provided. I will say this is a tough week in Montgomery County. We had our second school shooting where a student was shot in a school in Montgomery County with a ghost gun, which made me stop and think about this bill I was going to come down here with. A ghost gun would not require this. Again, both of our shootings and both of our cases where students have been shot in schools involved a ghost gun being snuck into a public school. The victims in both cases were African-American young men that were shot in these cases. Those cases would not any longer be in the adult system. I think the possession of this legislature has taken a ban on selling ghost guns, but yet we're taking a lesser than aggressive stance against children who are bringing them into our schools. Simultaneously, at the same time that the shooting was taking place at my high school, we had another young man where 3 young men, 16 years old, 3 people were stabbed, and another person was assaulted with a handgun. First degree assault. If all we had was a first degree assault in my shooting case, we wouldn't be able to bring this matter in the adult court. There's a fiscal note. This bill will cost my office over $1 million.
Thank you, sir. Next.
Good afternoon. I've been a prosecutor for 19 years. The majority of my career, I spent prosecuting crimes against children. In recent years, my attention has been refocused of necessity on violent crime, guns and gangs, far too often in this context, crimes perpetrated by children against children. My commitment has never changed to make my community safer for everyone, but especially for our children. They are our future. If we're not doing this work for them, then what are we doing? Right now, our children are not better off, and if this legislation passes, the conditions will only deteriorate. In my experience, DJS has too often contributed to dysfunction rather than stability. I say that recognizing that there are some well-intentioned individual workers within the system, but some are not, and they're not held accountable. One example, at our LESCC, our local detention facility, in September of 2024, a 6'4", 300-pound staff member body slammed a 15-year-old 1/3 his size on his neck. As if that wasn't enough, the child laid seizing on the day room floor with a fractured neck. No one called 911. No one immediately sought medical attention. No one reported the incident as required to CPS. Days and multiple medical evaluations passed before it was properly addressed. And it was only reported to CPS when that reporting was less than forthright. And the parent only knew the extent of those injuries when I spoke with them. This incident is not an isolated one. I have many more incidents of concern at LESCC I'm happy to discuss, but these are systemic issues. So when prosecutors, law enforcement, court officials, and even the ombudsman, whose office this General Assembly created in 2024 raises concerns about safety of children in DJS custody and supervision, we are met with, where's the data? And I'm asking you to scrutinize the data you are given. I ask how recidivism is defined. I ask that the parameters and timeframes used, you scrutinize. Based on what I heard today, it doesn't seem that the acting secretary is counting juveniles who are now adults, which would be a farcity in a recidivism number.
Okay, could you please wrap up? Thank you. Next.
Hi, I'm Allison Healy. I'm the elected state's attorney for Harford County. Our juvenile system is systemically and unequivocally broken. It fails to hold juveniles accountable, but more importantly, as a court which is geared towards rehabilitation, it is incapable of rehabilitating the children and providing the necessary resources to rehabilitate the offenders it professes to serve. The resources simply do not exist. To provide an example, we had a respondent charged in adult court. By agreement, we gave DJS the opportunity to serve this offender in juvenile court. He was held in a juvenile facility in adult court, and I'll note, I've heard it a lot this morning, almost all of our juvenile offenders are held in juvenile facilities. They're not held in adult facilities. In fact, DJS fought us to take a juvenile into their custody at one point, which I'm happy to talk about if someone would like to hear about it. But we sent this individual back. He was sent to Victor Cullen. He was committed on September 16th of 2024 and sent to Victor Cullen for a shooting. He shot someone. By December 9th of 2024, he's on aftercare supervision. He's released, and then by April 23rd of 2025, DJS says aftercare's done, no more supervision, no more services. That's how quick the turnaround. That is what they are professing is services and rehabilitation. Well, as to no surprise, November 2nd, 2025, he's now charged in a homicide in Mr. Bates's jurisdiction. They are not serving these individuals. When raised to DJS, we brought this example to the secretary. They had no idea. Oh, I don't know anything about that case. How do you not know about that? That's an obvious, very serious concern. So I have to question their data when they're bringing those types of concerns. With all of that, the system is broken. I agree with Mr. Bates. We need to fix the system before we move. There's no rush to do this. I think DJS needs to correct and have the resources before we move forward. I urge an unfavorable report.
Thank you. Next.
Thank you. Good afternoon. I'm Laura Wilt. I'm the senior attorney in Baltimore City with Maryland Crime Victims Resource Center. There needs to be justice for all, the juveniles involved and the victims that they have harmed. I'm going to focus my 2 minutes on the reality of juvenile court in Maryland. The laws already in place have the effect of moving most juveniles to juvenile court. And the process that we have is critical. The juveniles are only moved to a juvenile system after evaluation, safety precautions are put in place, and services set up. By passing this law today, you're voting to put juvenile laws in place from the beginning. So you can't ignore the fact that juvenile court has its own set of rules, and those would be in charge if this bill passes. Those rules include trial in juvenile court must occur in 30 days if the respondent is locked up. If they're detained, your sexual assault victim in your jurisdiction will go to trial without any DNA evidence or forensic evidence. Is that what you're voting for? Another juvenile law is that the court has no ability to determine or change the length of a juvenile placement. You're going to get a call from a mother in your jurisdiction who had a gun stuck in her face and her wallet stolen. She can't imagine why the average length of stay in a placement is 3.5 months, according to the Data Resource Guide. This is solely determined by the Department of Juvenile Services. Juvenile court, a judge cannot change that. Do not believe anyone who tells you that there is meaningful involvement by DJS until the age of 21. It's not true. Victims ask for your unfavorable report because juvenile laws do not give the courts the ability to enforce things like rehabilitative programs, treatment, restitution. This could help prevent victimization. Those laws cannot be enforced in juvenile court. And there were 2 other juvenile court rules that I wanted to bring out, but I've lost time. Hopefully there'll be a question.
Thank you. Thank you for wrapping up. Next.
Thank you. For the record, my name is Robert Harvey. I'm the state's attorney in Calvert County. I've been practicing law in this state despite my young appearance for over 40 years. And for as long as I can remember, the juvenile justice system has been broken. Not enough staff, not enough programs, not enough facilities. Unfortunately, these shortcomings continue to exist to this very day. In fact, things may even have gotten a bit worse. And that's why I believe this bill is not a good idea, not now, not at this time, because it will add more responsibility to a juvenile justice system that can't effectively handle what it's got on the plate right now. Let me give you an example of one of the problems we see with DJS. In Calvert County, we currently have a case involving a 17-year-old juvenile charged as an adult because he pistol whipped another individual. The juvenile had 13 prior contacts with DJS, including several assaults, all of which we have not talked about, were closed at intake by DJS. Informal, closed at intake, never made it to court, never made it to the state's attorney's office. Closed at intake. Now, why were they closed? Well, we don't know, because the process, there is no transparency. DJS has its own rules, and they apply them, and they release people without any referral to court. I have to assume that public safety was not a primary consideration in the discussion. In fact, I think the considerations are based upon lack of programs, lack of facilities, lack of bed space. So my message today is this: let's pause. Let's take some time to study DJS and the juvenile justice system. Keep what's working, discard what isn't. Let's consider creating a program in juvenile modeled on the youthful offender program at Patuxent Institution, a secure facility where juveniles can come, receive education, counseling, and treatment over an extended period of time. A program focused on achieving real behavior modification, not just cycling kids in and out of the system. Thank you.
Thank you. Questions? Delegate Simpson.
Yes, I'm curious. Thank you very much for being here. I'd like to know what the data is to support. Like, what is the time period in which we were only charging kids as juveniles and the outcomes, as opposed to now that we are, putting them in adult detention? And I'd like to know, so what are the outcomes? Because I hear, yes, about the victims, but are they really being served? I mean, what are the outcomes for these kids?
Well, I can tell you in Calvert County in the past year, we had 7 cases. We're a small jurisdiction.
I'm aware of all jurisdictions.
All right.
I've worked for the state for 30 years.
Okay.
So
We had 7 cases of juveniles charged as adults. Out of those 7 cases, 5 stayed in adult court. Most of them involved very serious crimes such as murder. They were convicted and they were sentenced to the adult system. However, recommendations were made to put them in Patuxent Institution Youth Offender Program, a program that the legislature has enacted and funded, and it works. I encourage you to invite Dr. Kwiatkowski down here to come to you and explain this program, what they do. Kids, some of these kids have very serious problems. You can't just fix them overnight. It takes time. They've got to go through a graduated program, education, training, behavioral modification. That's what Patuxent's got, and that's what I'm recommending to put in the juvenile system. Give them the same thing.
Okay, what I'm asking is for data. So I'm saying, do you have like a dashboard? Do you have a report that you can send to us and show us the great outcomes of charging juveniles as adults? That's what I'm asking for.
Well, if I may, the booklet that I talked about that I know my office has given every single member in the on this committee, Juvenile Justice Report, on page 29, 30, and 31, we talk about the data of, in 2024, my office sent 118 young people back in the juvenile system from the adult system. Within 18 months, over 30% of them reoffended. Let me just take, 2 kids. One was a handgun possession, was sent to the community, and then went AWOL June 2025. Another one was armed robbery, went to the community, reoffended August 2024. Charged with another handgun. Here's another one, handgun possession, probation, reoffended, charged with motor vehicle theft. This is within 18-month, just within Baltimore City.
How old are we talking about?
We're talking about kids 16 and 17 years of age. The youth that you wish to now put all in the juvenile system. And what we realize here is, within 18 months, these kids are reoffending. And then when we look at the programs, most of these programs with those 118 kids we sent back were one program, Victor Cullen. That worked out really well because he was only there 100 days, and then right after that, he did some major offenses. Now he's doing 105 years out of Baltimore County after doing the Victor Cullen program. But most of these community program, probation, community, Victor Cullen, Greenbridge. And so it talks about the programs. But the things that we don't understand is that what was happening, and I'm not blaming Acting Secretary Tolentino, DJS did not have the bed space. They would start a kid in the program and then say, you know what, we need a bed because we have 24 more kids. You've done 3/4 of the program, let them go. And they really didn't do the investment. What we're saying, all of us are saying is, we would love to put the kids starting in juvenile, but you gotta fix DJS. You've gotta fix the programming, because what's gonna happen is you're gonna send thousands of kids back. And then what you're gonna have is thousands of kids who've reoffended in another way. And we're just saying, let's just fix the system.
So does this data show that if you're sending them to the adult court, they don't reoffend?
Well, they're in prison at that moment in time, and they're not reoffending in the sense they're in prison. They're doing some of the youthful protective programs.
And
that's what they're showing.
And to add to that, when they're reoffending, at least in our jurisdiction, when we're seeing them reoffending, they're getting charged as adults for very serious crimes. So they're going to spend the rest of their lives in jail, right? Is that what we're signing our children up for? Is to then do a life sentence? Because that's what's happening.
I don't see, but you're not giving me your.
Well,
I feel you're threatening us with this is what's going to happen. I'm sorry. I'm trying to find the right word and put it nicely, but I feel like you're threatening us as a community, saying this is going to happen if. But on the other hand, you're not really saying it's not going to. I mean, if they're in the adult jail, how is it different than what you're talking about?
I guess I feel like this booklet here kind of breaks it down. This booklet here breaks down. I mean, did your office give you this? My other question is, how many have ever been to a juvenile facility?
Hold on. We're asking the questions, sir.
All right.
Hold on.
And you already know the answer to who you're asking whether or not I've been to a juvenile facility. So I have been to a juvenile, and I used to be at Child Protective Services. I married myself a juvenile protection officer. So yes, I am fully aware of that. What I'm saying is that I don't see where your data supports what you're asking for. I understand this is what we're doing, and I hear you're saying the juvenile system, but what makes you think that the adult system is able to handle them? I think we've proven time and time again, data says it's not handling them. And you know, as the child welfare, I want to know, what investigation did you do to see what happened to that child for them to be doing it, especially at such a young age? What are you looking at? If this child is, a sexual offense, this child is burning things, we all know, you know this. This is a sign and an indication that something bad is happening to that child. And what are we doing to investigate, their safety?
You've answered
their safety.
Yep, you've answered my question. That is not the role of the prosecutors or public safety. That should be the role of DJS. DJS does not have the services to do that investigation. So why are we going to put more kids in a program, in a facility in DJS that can't do what they got to do now? They should be doing those investigations.
I don't know if that's true, because I kind of noticed we keep giving a lot more money to our prosecutors to do programs.
Delegate Simpson, I'm going to have to interrupt this conversation that you guys want to have privately. If you want to do that later, we could do that.
Yes.
Delegate Valentine.
Thank you, Madam Chair. Thank you, Madam Chair, and thank you, panel, for all the state's attorneys on the panel today. And my question is, or I have a couple of questions, and they're going to be directed to Ms. Wilt. And I only say this only because of, I know your past experience in juvenile prosecuting, and as well as one question in your current role. So that being said, and some of it was touched on by Mr. State's Attorney McCarthy, but I wanted to kind of follow up on it with the age of 21. So is it true juvenile court has no meaningful authority or involvement with individuals up to 21? Doesn't juvenile jurisdiction cover individuals up to the age of 21?
Right, I think you heard that from a couple of us today. We said, don't fool yourself. to think that jurisdiction is meaningful until the age of 21. Juvenile court has the ability, when the crime comes in, if it's proven in juvenile court, the court can place that juvenile one time. They can go to a juvenile placement one time. Then when they come out and go on probation, in order, because the laws are written the way they are right now, in order to ever be taken back out of the community or do anything on a violation of probation, they have to commit a new crime, which then means they're already an adult. That's an adult court. So after they are out of that 3-month placement, which Data Resource Guide tells us 3 months is how long they're going to be in placement, there's going to be a probation order. That is the only thing the juvenile court can do after placement. A probation order, which is meaningless because we are not allowed to remove them from the community unless they commit a new crime or they totally abscond, or third, if they recontact a victim, which is probably a new crime anyway. Does that make sense? So really, yes, there'll be a piece of paper, but that's not meaningful supervision.
Okay. So my second point is another argument that's been touched on quite a bit today. And again, I'd like Ms. Wilt's thoughts on this. We've heard arguments about how the greatest harm of the current system is that juveniles are housed in adult jails. I think we all agree on that. Obviously, we heard a bill last week, HB 389, that would prohibit anyone from under the age of 18 being in an adult facility. Could you tell me if you are in favor of that?
Yes. In fact, I believe I was in the House testifying in favor of that bill. I missed the Senate hearing. So Maryland Crime Victims Resource Center realizes that we need meaningful response, but we need to do so in a way that is appropriate for the juveniles that are in the court. They need due process. They need proper treatment. They should never enter into an adult jail when they are under the age of 18. You have that bill. If the argument is that these juveniles are being hurt because they are in adult jails, House Bill 389 will prohibit them from darkening the door of an adult jail. It will require DJS to step up, start taking these kids from the moment of arrest. So Delegate Simpson was asking about charging youth as adults. The question is, if they're being arrested as an adult, but then processed by Department of Juvenile Services while we write these reports to figure out if they were a victim, while we figure out what safety precautions can be put in place. All those things, they don't happen if you're in juvenile court. I think I answered your question. Yes, I'm in favor of that bill. And yes, Maryland Crime Victims supports that bill because we realize treatment for juveniles means a safer community.
Last one. I'm glad you mentioned Maryland Crime Victims because that is my last question. My office received an email from Ms. Roper, who's the founder of Maryland Crime Victims Resource Center, and I know has a lengthy history of over 40 years, and she couldn't be here today. So my question to you was, could you at least relay, I know she wanted to talk quite a bit about both juveniles and victims, and if you could just put in a 1 or 2 sentence of what she wanted to relay to the committee today, 1 or 2 sentences.
The main point she got across, and hopefully all of you will have a chance to read her letter, is that she believes that the juvenile justice system needs to develop long-term intensive care treatment programs and stop the revolving door before you put the most serious offenses in it. We need to look at the juvenile justice system and change the laws, and then let's get the juveniles, even the most serious offenses in that system. Thank you. I hope you read her letter.
Okay. Thank you, Madam Chair.
Okay, this is a friendly reminder. This is a friendly reminder that we have 45 more witnesses and 5 more bills. But go ahead, Delegate Carter.
Thank you, Madam Chair, for the reminder. Thank you all very much for your very compelling testimony. We appreciate it. I wanted to just ask you to respond to comments that I'd asked one of the earlier panels regarding the concerns the judiciary had about panel attorneys and also about time. And the 120 days, they said that it's going to be very difficult to be within, the judiciary said it's going to be difficult to be in compliance of the 120 days to try the cases or to, I'm not sure I understood exactly, you probably understand it better than I do. But they say compliance, that the waiver hearing to be held no later than 30 days after the detention is granted. In the types of cases this bill would return to juvenile court jurisdiction, it will be difficult for the present time and for the required studies to be ordered and completed within the time frame. That adult murder trials within 120 days would be difficult to complete. The problems are multiplied in the juvenile court for similar charges. So they're exacerbated in juvenile, if you can respond to that. And then I also, one of, I guess, Mr. Bates, one of your assistant state's attorneys is texting me, must be listening to the hearing right now on live. Told me that there was a fiscal note done by 8 jurisdictions. I think some of yours were in it. It's Wicomico, Frederick, Carroll, Prince George's, Anne Arundel, Baltimore City, Baltimore County, Howard, Montgomery. I think most of yours. That between all 8 of those, it would be about a $6 million fiscal impact. Why? I don't understand. The testimony that we had earlier was that it's just transferring the decisions to the other court. Why would it cost more? Doesn't seem like to make any sense to me.
Well, I'll go ahead and start out. One of the things that people don't realize, and once again, it's in the book, we broke down in the book really the way the system should work and what's going on. For instance, in Baltimore City, the public defender's office had at least 150 show cause orders by the judiciary. What's a show cause order? Show cause order is when the court pretty much has had enough of it and something's broken. That was because there were not enough panel attorneys. So part of the fiscal notice, you're going to have to increase the public defender's budget probably by at least $1 million, $2 million to pay the panel attorneys. They pay panel attorneys $60 an hour. No defense attorney is going to take $60 an hour. Now they want $65. They're not going to do it $65 an hour, which means also all these cases will only be exacerbated. The other issue that we need to understand is, for instance, I'm going to give you a hypothetical. We talk about it here in the booklet. If a juvenile is arrested for a gun, let's say in January, and they're in the adult system, they're like, oh, it takes a year, 2 years. Well, people don't realize the reason the case is postponed in the adult system is because DJS has to do a report. The holdup isn't on the prosecutors. The holdup is on DJS or the public defender's office to get an attorney. By the time they do that, the young person, say, is in the juvenile system. Then once they're in the juvenile system, it probably takes 3-4 months to have that panel attorney. Then as soon as we go to court and to trial, then let's say there are 8 or 9 witnesses. Because there's so many cases in the juvenile system now, you start for an hour and a half, then you stop. And then you come back 3-4 months later. Then you do another hour and a half, then you stop. Before you know it, this youth has now picked up 1 or 2 more cases because they weren't getting services. Also, what you also realize is that if they started out incarcerated, they are released. The system is so overburdened and broken. When you look at the fiscal note, you need more public defenders, you need more prosecutors, you need more judges, you need more magistrates, you need more money in the facilities to hold the young people. When DJS says, oh, we're going to hold every gun, no, they hold you for 24 hours and then you leave. And so when you understand how the system is so broken, we just need to fix the system. And that for us, once again, I'm going to talk about this book till I'm blue in the face. If you read the book, we give real case studies of what's happening. And we don't give the names, of course we can't, but really what is happening. So what we're seeing is cases, because they don't have attorneys in Baltimore City, are taking a year, a little more than a year to have their day in court. And that's too much.
Can I say, the types of
We can't have everyone answer the question.
Okay.
Yeah, that's fine.
Do you agree? Are you okay?
I'm okay, but he took all the time of all the other people. I'm just kidding. No, it's all good.
If you don't mind, Mr. McCarthy, maybe someone else will ask you a question. We have to move on. Delegate Phillips, please.
Thank you, Madam Chair. As I really consider this bill, and I hear everything that you all have said, the system is broken. But from a policy perspective, it appears from all of the research that sending kids to an adult system and then many of them coming back to a juvenile system is extending the time even more. Isn't it true that all crimes of violence, all crimes of guns, or at least referred to the state's attorney's office? Juvenile crimes, all crimes of violence, all crimes of, by law, are they not referred to your offices?
I don't know about that.
Okay. If, in fact, they started in the juvenile system, they would still be referred to your office, right? I'm asking, somebody, they would still be referred to your office.
Only as November, only
Okay.
as of November.
Okay,
So
but all of them have to be referred. There's been a conversation about whether you bring kids down or whether you move kids up. Let's assume that this bill gets passed, and there are individual 16 and 17-year-olds who commit a crime that you see as one that should be tried as an adult. What are you going to do?
So we're obviously gonna, I can answer that, we're gonna follow to have them waived up to
All
adult
right.
court.
I just wanted to ask that question.
But that's
so
not-
it's not. So this doesn't suggest that children that you believe should be in the adult system you won't have the opportunity to move them to the adult system.
No, of course, okay, so, yes. I think the process is important, and I think what everyone sort of misses, because they look at us as prosecutors who just, we're the big bad guys who want to send everybody to jail, right? That's what everybody thinks of us, but that's not the case. First and foremost, our biggest argument is that these kids are not getting what they need. They're not getting what they need. The process is currently, we don't care, and there is some notion that we care about the shift of the burden. We have the burden all the time in every case. We're used to that. That doesn't bother us. Well, the issue is, and I heard it said earlier, and it's actually baffling to me, is that when the transfer is happening, the burden is on the defendant to transfer it back to juvenile court. They have every incentive to cooperate with psychological evaluations, to tell us everything about their history, to give us all of the information to demonstrate that they're amenable to treatment, that it's appropriate for them to go back to juvenile court, all of that. So we get all of that in an evaluation because they have an incentive, because it's their burden to show they should go back. And let's not pretend that all of us at this table don't look at that. We make decisions in all the cases. The one I just said, we by agreement, because of the things my prosecutor in that evaluation said, I'll give DJS the opportunity. So it's not like we're just like, nope, we don't care. We look at it, we look at the data. But when they're in juvenile court, they don't have any incentive to do that because there's no burden. So we don't get to know any of the things. To Madam Delegate's point over here, we don't, Delegate Simpson's point over here, we won't have any reason to get that information, right? They have no incentive to tell us all about the things that happened to them. And so when we don't get that information, and I heard someone say earlier, well, then they're not amenable to treatment. So you would have us go into court and say that a juvenile exercised their right not to talk to us and that we're going to use that against them? I mean, that's a violation of their constitutional rights. They don't have to talk to us. Why would they talk to us?
But
right?
it just sounds
And
like,
so,
I'm sorry, I'll let you finish. Go ahead.
So the process, right, is that we are able to get that information, and by doing it this way, we're able to make meaningful decisions about what's best for the public safety of our community, but also what's best for the juvenile. Our biggest concern as a group, as the MSAA, is our public safety is affected, yes, because these kids are not getting the services they need. They're just not.
If they're charged in juvenile court.
Right.
But if you
From DJS.
if you come in as a transfer, it's all hands on deck.
Right.
DJS is suddenly trying to get that report done right away. It's public defenders hiring their own experts. If you're charging juvenile, first of all, they're on the street. We get the case a couple months later. You don't know what the heck's happening. You got to get, let's schedule an appointment for an interview. It's a completely different entry. And I think the Department of Juvenile Services and Public Defender, they don't want this current process because it is very hard. And guess what? The juveniles benefit from that intense transfer process. It helps get the information to us quicker. You put it through a waiver, it's going to be dragged out forever because they're going to be on the street. It's not an emergency. Nobody's going to be worried about getting that psychological done. 6 months later, and how many more victims is what I'm afraid of.
And to that point, a lot of our big, longest delays are from the public defender's office, who sits here and says it's the delays. They're the ones because they don't like what DJS has said, so we're going to hire our own expert, and then it takes months and months to get an appointment with the expert and months to get the report from the expert. So the long delays you hear about are not from any of us sitting at this table. They're a direct result of either DJS or Defense Counsel.
But you would agree that if a young person is in the DJS system, the process moves faster for that young person. I think
Not
what you're saying is
No, not
okay,
necessarily.
Well, I would also, one of the things that's problematic when you take more serious cases, there are really strict timeline guidelines in the juvenile system that do not apply to the adult system. That's why you need more personnel, because I think it's every 15 days, if you're holding a child, he's entitled basically to a bond review every 15 days. When you're looking at the more serious cases, these are the cases that potentially could involve DNA, cell phone, computer data dumps, incredibly intensive stuff. So sometimes this stuff can exonerate us. DNA can exonerate. It can implicate, it can exonerate. You want these thorough investigations to be done. The timelines that are in place currently in the juvenile justice system do not work for the more complex cases that we traditionally do. It crushes our young lawyers because these cases are so labor intensive, because whether we're talking about body camera footage, whether you're talking about recording cell phone conversations from the jail, there's all kinds of stuff. It just, to get a DNA result in 30 days, you're gonna have murder cases or serious felony matters where you don't have DNA or phone extractions or computer extractions.
But once again, aren't those the cases that you're going to have waived up to adult court?
Depends upon the charges.
Okay.
It depends on the charges.
Thank you.
And it would depend on the judge.
Thank you. Let's go to the next person. Delegate Stinnett, please.
Yes, thanks, Madam Chair. I'm just trying to get some clarity on, isn't it true that under this bill, murder, rape, carjacking, manslaughter remain automatically charged as adults? And also that this bill does not touch the charging process for those charges?
That's true.
Sexual assault with a weapon would go directly to juvenile. That's the third degree, 307A. And if a 14 or 15-year-old commits first-degree murder or rape, it goes directly to juvenile. I can't remember the others. I'm sure you read the list. So armed robbery would go directly to juvenile. So all of those, and first-degree assault. I had a woman shot in the arm, lost use of her arm in Baltimore City. The only charge related to that victim was first-degree assault. And that case would have gone directly to juvenile court, where an intake worker would be the one to decide whether that person should be held instead of a court of law. We believe in our courts and due process. That's why the adult system's appropriate for those serious crimes you just mentioned.
Thank you. Thank you, Madam Chair.
Thank you. And the last question for this panel is our fearless chair and sponsor of the bill, Delegate Bartlett.
Thank you very much. I have a litany of questions. I'm not going to ask all of them because we are here late and I know how to reach you all, okay? So my first question is, and I wanted to direct this to State's Attorney Bates, we do not have the report. I have it now. I just got it a few minutes ago. When was it prepared?
We worked on this over the summer. We began grabbing data over the summer, and we finished it probably about 2 weeks ago. We wanted to have the most up-to-date data as possible.
Okay. Is there an MSAA dashboard of any kind?
We don't have one for MSAA.
Okay, that might be something you might be interested in. I heard a lot of fix the system, but quite frankly, I also heard the system's been broken forever. So I don't think we can wait around to quote unquote fix the system. To State's Attorney McCarthy, I want to ask you a question. You said that 3 to 4 months, it takes sometimes 3 to 4 months in Montgomery County
before there's placement, right?
Yep.
Okay, so, but you also heard, because you were here and you heard the testimony, that kids that are charged as an adult and that are held in adult facility are in isolation. You heard that part? Or it's restricted housing? I think that's the euphemism.
Well, there are I know that you're in favor of sight and sound restrictions. I think, that I know that in my county, they are kept separately it's a wing, they're in a separate pod, apart from the adults. They're housed separately without a sight or sound of the adults.
Right, and I've seen them, and I know what that looks like, and it's a curtain going down. No, I'm honest, this is in my county, I'm speaking of my county.
Okay.
But my question was, did you hear that the individuals who said that when a child, sometimes, it has occurred in the state of Maryland, that a child who is held as that is being charged as an adult and held in adult detention could be there on average, and this was a quote from the DJS secretary, of 140 days. And in my testimony, I said 140 to 90 days. Did you hear me? Did you hear any of that?
I did hear that.
Okay, so is the 3 to 4 months placement horrible when you're comparing it to possibly 2 to 3 years of isolation?
Well, again, I don't think they're isolated. I will tell you, in my jail, there's a pod, and they're there with other young people who are similarly situated. They're not in isolation.
Well, I actually know your situation because of the State's Advisory Group report that we got with respect to being out of compliance. I'm not going to go over it right now with you, but you all were out of compliance as well. But I'll go over the details with you later. In fact, but you all corrected it. But you were out of compliance. So folks were in restrictive housing. Harford County spoke, yes. Would the individual that you were speaking of, does that apply to this bill? The charge that you were speaking of, I think it was somewhere on the lines of murder or.
It was, and it didn't apply to this bill, however.
Okay.
So again, to what I was speaking to earlier, my position, I personally prosecuted the case. I was there for the hearing, and I said.
But here's the thing,
the child will be better off.
Hold on, I'm sorry to interrupt you. The reason why I'm interrupting you, and you know this as a litigator, I have a short period of time to ask a whole lot of questions, and I'm already going too far. So I just want to make sure that that situation does not apply to this bill.
It doesn't apply specifically to this bill, but there was a court order ordering DJS to take it.
That's fine. That's a whole nother issue. My last question is, and this is just by a nod of the head, has anyone on this panel ever heard a victim say something along the lines of what we heard, and that is, I'd rather the accused child receive services rather than harsher penalties? Has anybody ever heard that?
Oh, absolutely.
Okay, great.
And then I've seen their hearts broken when they walked in. Are you kidding me? The court can't do anything. They can't enforce it.
Right. I just wanted to make sure that it wasn't just said on one side, that it's also true on the other side. That's all.
They want it,
That's all.
but not in this system.
Gotcha.
Thank you. Thank you. I seem to have overlooked Delegate Conaway. I'm sure he has a poignant question for you.
Mr. Bates, are you saying that if a juvenile is waived down from adult, they get services quick? But if the individual comes in through the juvenile intake, there might be a lack of services, there's no all hands on deck? Is that what you're saying?
What I'm saying is juveniles aren't getting service quick at all. It doesn't matter how they come in. Number one, if they're in the adult system, at least if they're in Baltimore City in the adult system, with the BCIJJ, whatever it's called, in terms of where the juveniles are being held, they're getting services through DPSCS. So right there, they're getting services. I recognize that isn't the whole state, but yes, they're getting services on the adult side. And I know that because I've spent time with them recently. On the juvenile side, they go in the juvenile, they are then, let's say with a gun, the judge looks at it, talks to them, and then say they may, and DJS is recommending they go to the community. Once they go to the community, they're not getting any services. We're also finding out, in this report you also realize, they're not going to school. And what we also realize is then they may have the ankle bracelet, they cut off the ankle bracelet, they don't have an attorney. Because they don't have an attorney, the case is postponed, postponed, postponed. Then when they finally do have an attorney, then they start trial. Once again, start, then it's postponed, start, then it's postponed. You know, one of the issues also that I'm really concerned about is when handguns, it sounds like it's a little, but also you talk about the research. What about the frontal lobe development of young kids with guns? And those are the issues that I think if we really wanted to put the money in DJS to have the services to really examine these issues with the children, to give them the intensive services needed. But we're not doing that. As my partner likes to say, we're building the plane and flying at the same time. Eventually it's going to crash.
Thank you very much.
All right. So I have a question. So everyone in the room is 100% in agreement that we need to offer services to children as opposed to putting them in jail. Is that an agreement? Did I hear that? Did I hear that? Could be. No?
Effective services, and that's not what we're seeing.
Let me restate that. Everyone here agrees that we need to offer our children effective services rather than putting them in jail. Is there anyone on the outside of that?
Depending on the charge.
Depending on the charge.
I mean, look, if it's a murder.
If it's a murder,
If somebody commits a murder.
Yeah.
You're in the last panel. You guys, thank you for being here.
Thank you.
Thank you.
I just didn't get your report, but I mean, I have it online.
Ma'am, it was emailed to you all, and your gatekeepers received the hard copy.
Yeah, I got it.
Your gatekeepers received the hard copy.
I didn't get it.
Take the end seat for a quick escape in case. I'm the last.
Favorable witness, please move forward. Thank you for being patient.
It's not a problem at all. Madam Chair, members of the committee, my name is Brian DeGregory. I am the state's attorney for Kent County. And I want to thank you for this opportunity to testify. First time I've ever done this. And I want to say, look, I appreciate the goals behind House Bill 409 and the committee's continued focus on improving outcomes for young people that are involved in the justice system. As an elected state's attorney and former public defender, I share the belief that rehabilitation should always be a central consideration when dealing with juvenile offenders. And my concern with this bill, House Bill 409, is not its intent, but its practical impact. The bill significantly limits prosecutorial discretion, which I value, and expands juvenile court jurisdiction without ensuring that the juvenile system, and specifically Department of Juvenile Services, has the capacity and resources necessary to manage serious cases that would be redirected there by this bill. Currently, long-term placements are non-existent and length of probation is limited. Rehabilitation does not occur in a matter of months, and when serious cases are redirected without corresponding investment in long-term placement, supervision, treatment services, the victim support, neither rehabilitation, accountability, nor public safety will be served. Well-intentioned, House Bill 409 is putting the cart before the horse by changing the structure of jurisdiction before the underlying infrastructure is fully in place. For example, recently in Kent County, I have young people placed for offenses less serious than those covered in this bill, return to the community and reoffend. And when placement is brief and supervision is short and at times stretched thin, the result can consistently fall short of benefiting the juvenile and the community. That gives me pause about expanding jurisdiction for more serious offenses before those gaps are addressed. Finally, I do not view this as a choice between rehabilitation and public safety. we should pursue both. However, meaningful reform must be paired with infrastructure and resources necessary to support it. So that's why I asked you to delay action on this bill.
All right, thank you so much. Are there any questions for this witness? Thank you, sir, for being patient. I really appreciate it.
My pleasure. You all have a good night.
All right, bye-bye. Delegate Schmidt, come on down.
Do I get cheers or boos,
Well,
Madam
you
Chair?
were a member of Judiciary and you left, so what do you think?
It was not my choice, Madam Chair, not my choice.
Well, why did I see you in the hall doing that happy dance? So Delegate Schmidt, your bill is House Bill 449.
Yes, Madam.
And is it just one witness with you today?
I should have Alan Culver, Samira Jackson, Sheriff Crisafulli, and Allison.
Oh, right here. Okay. Give me a second.
Fantastic.
Let me get my, sorry, I was on hold. Oh, no, that is.
Sheriff Crisafulli is not able to make it. He's on the job in Worcester County.
Okay, and I have, well, the only people I have is Delegate Schmidt, and Alan Culver from Carroll County.
Allison Healy, that was the one I think got confused earlier. I had.
Oh, gotcha.
Yep.
Okay, okay. All righty, so, and your name, sir?
Alan Culver. I'm special counsel.
Oh, okay, I got it.
State
It's all
Attorney.
making sense now. Thank you very much, and Delegate, you may begin whenever you're ready.
We got it. Well, good evening, Chair Bartlett. Great to see you in your new role. My esteemed former colleagues of the Judiciary Committee. For the record, Delegate Stuart Schmidt from District 33B. The purpose of House Bill 449 is simply to amend a provision. It's a one-line bill on page 3. And this provision of law is regarding law enforcement officers may conduct a lawful custodial interrogation of a juvenile under certain circumstances, generally relating to juvenile law, which we've heard a considerable amount today. This ensures the best option for the juvenile, for the juvenile to be chosen, whether that is speaking with an attorney first or speaking with law enforcement. There are certainly circumstances where consulting an attorney first is appropriate and in the juvenile's best interest. However, there are also certain circumstances where allowing a juvenile to speak with law enforcement can not only help the investigation, it can also benefit the juvenile. As currently written, the Child Interrogation Protection Act, which I'm sure you all are well aware of, has the ability to effectively conduct investigations. Following just a few years ago a tragic shooting at Joppatown High School, investigators were hindered in their efforts to locate the firearm. We've heard this testimony in the past. House Bill 449 will improve public safety in Maryland. The U.S. Department of Justice has found that when juveniles involved in violent crimes, more than 50% of those crimes are committed in groups. When a juvenile is arrested and refuses a statement, due to our laws, investigators may lose critical information and time to identify accomplices or prevent additional crimes. Allowing flexibility in this situation can mean the difference between offenders being apprehended or remaining at large. This is just a tool in the toolkit. More importantly, providing a statement can also benefit the juvenile. It may clarify the juvenile's level of involvement and demonstrate lesser culpability where appropriate. Opponents will present arguments about Miranda rights, the kids not understanding their rights, or the adults not understanding their rights. As my esteemed colleague likes to say, Delegate Conaway, who's not here, it comes down to education. This bill is also about prevention and options. For these reasons, I respectfully urge a favorable report on House Bill 449. Thank you for your time and consideration.
Go ahead, Alan.
Good evening, Madam Chair, Madam Vice Chair, members of the committee. My name is Alan Culver. I serve as special counsel to State's Attorney Haven Shoemaker, State's Attorney for Carroll County, and longtime House of Delegates member. I'm here today to testify in favor of House Bill 449, which would amend the Juvenile Interrogation Protection Act. Up front, I think it's important to say what this bill will not do. This bill does not limit a juvenile's Fifth Amendment right not to speak to law enforcement. This bill does not limit a juvenile's Sixth Amendment right to be represented by counsel or to speak to counsel prior to speaking to law enforcement. This bill does not affect the requirement that a juvenile be advised of his or her Miranda rights when taken into custody and questioned. The bill does not remove the requirement that law enforcement make all reasonable efforts to contact a juvenile's parent or guardian prior to speaking to that juvenile. All this bill does is allow the person in the best position to know what's best for the juvenile to advocate and make a decision for the juvenile, the parent or guardian. This bill allows a parent to waive the requirement that the juvenile speak to an attorney before speaking to police. Let's let the parents and guardians make decisions for their children, not a statute. Under this bill, a parent or guardian could still speak to an attorney on their own, allow a juvenile to speak to an attorney on their own, or even prohibit the juvenile from speaking to law enforcement. All these options are still at the disposal of the juvenile and his or her parent or guardian. But it would be the parent or guardian making the best decision for the child rather than a statute. A statement given by a juvenile may often be helpful to further an investigation and lead to the recovery of evidence and identification of other individuals involved. Statements given by juveniles can benefit the juveniles. I handled a home invasion case where a juvenile and 4 co-defendants, adult co-defendants, had a firearm, broke into a home and took items from the home. The juvenile suspect provided a statement that limited the juvenile's culpability in the case, which significantly benefited the juvenile in the disposition of the case. I urge a favorable report for House Bill 449, as this bill is in the interest of juveniles and their parents and guardians.
Thank you. Pam?
And you know who I am, probably tired of hearing from me at this point. Allison Healy, Hartford County State's Attorney. In addition to the evidentiary value that you've heard about from both the delegate and Mr. Culver, all defendants have a constitutional right to an attorney, including the right to waive their right to counsel and to represent themselves. By not permitting parents as the legal decision makers for children to make determinations regarding the presence of counsel for purposes of interrogation, that is a violation of their constitutional rights. Further, to suggest that parents will not make decisions in the best interests of their children is preposterous. Parents have the right to make decisions for their children in essentially all other areas of their lives, and this should not be different. We have juveniles who have been charged in cases as serious as murder or attempted murder due to their inability to speak to law enforcement despite their parents' wishes. Had we received the information that we later received through counsel, they would not have been negatively affected by being charged with serious charges as a direct result of the current state of the law. Had that counsel, the information the counsel provided to us later, they would never probably have even been charged. But instead, we're seeing blanket, don't talk to them. And when parents are saying, we want our kids to talk, they don't have anything to hide, let them talk. But this is what we're seeing. And it is against their constitutional rights. It's not in the defendant's best interest. These parents have parental rights. We let them decide things for their children every day, educationally, medically, financially. This should be no different. And so with that, I urge a favorable report for this bill.
Thank you. Delegate Conaway?
Thank you, panel, delegate, for coming in. So how old do you have to be considered an adult?
18.
So up until the time that you're 18, it's pretty much thought that your parents could make the best decision for you?
As the parent of a almost 17-year-old, I'd still say yes to that question, but no. I mean,
really?
I mean, what I'm saying is I do believe that parents are legally obligated to still make decisions, right? They still have to make the medical decisions. They still have to make the financial decisions. So I'm not saying they shouldn't speak to their child and have a conversation. Obviously, they have to speak to the child about what they should do. And I'm not saying the child shouldn't have input, but the parents have rights as well. They are still legally responsible for their children. Under the law, they would still be legally responsible for some of the decisions their children make.
Sure, I understand that, but sometimes the children are going to make decisions that they're going to be responsible for. For example,
100%.
let's say if you're a responsible child and you have your own car at 15 and a half or 16 years old, you might make your own decision on whether you're going to drive in and how fast you're going to go. Is that right?
That is right.
And then your parents might not be there to tell you to slow down. Is that correct?
Sure.
Okay. All right.
My son will be 18 next week. I wish I could make all those decisions for him.
Well, I had my own car when I was 16, and my dad trusted me to make my own bad decisions, okay?
Yeah, that's right. Me too. Me as well.
Yeah.
I have one question that I will always ask when it comes to any repeal of the Child Interrogation Protection Act or any tampering with it. If the child is found guilty, Who loses their liberty? The child or the parent? So who goes to jail?
Well, of course, the child goes to jail.
Exactly.
However, we are seeing children who are being arrested, processed, and going to jail because they're not talking to us.
That's fine. They have that right.
Sure they do. But despite their want to talk, right? Despite their parents saying they should talk to the police.
There's nothing in the bill that I remember that says that a child cannot walk out of the room after talking to a counsel, go home, talk to their parents, come right back into the station and say, Johnny wants to talk now.
But this doesn't stop them from talking to an attorney, doesn't stop them from their right to talk to an attorney.
Say that again?
Doesn't stop them from their right to talk to an attorney. They still have the right to talk to an attorney and receive advice from them.
Right, and they still have the right to talk to their parent, and their parent still has the right to come back and say, Johnny's ready to talk now.
Okay, but let's put it in reality, because I think a lot of us have experienced teenagers. If the parent decides to say, my child, I'm waiving their right and they can talk. If the child doesn't want to talk, he ain't gonna talk.
Good.
That's
a good thing.
You know what I'm saying?
They have the
So
right to remain
I think
silent.
we're talking about situations where the children, they want, I don't know how else to say this. These are situations where they want to talk, but an attorney at times is speaking for them, right? And saying they're not going to talk. Right? And the parents is saying they want to, you know what I'm saying?
I do. I understand what you're saying.
The parents and the attorneys are saying different things. And once a child is represented by an attorney, he can't then speak up and say, no, I want to talk.
Okay.
Do you see what I'm saying? He can't.
I see exactly what you're saying.
Once law enforcement, once that right to counsel is invoked, we can't then go back to the child and say, is that really what you want?
I understand. I see exactly what you're saying.
And I think we're seeing that more than you would think.
Yeah, but you do know that that is part of their child's constitutional right to not speak or to speak if they want to.
Of course it is.
And there's nothing in the law that says a child cannot go home, leave the room, go in another room, and mommy and daddy can tell them all day long, you need to talk, and that child can talk. There's nothing in law that says that. And if there is, I need you to show it to me, because I've never seen it.
No, but I would say under your scenario, if the child went back to the police station with their parents, law enforcement would be required to contact an attorney.
Right.
Typically, that attorney they're contacting is on the phone. It's somebody who's never met the juvenile, who has no idea about the background of the juvenile.
Right.
And I will tell you this, 99.9% of the time, that attorney is going to say, don't speak to the police.
It's okay, here's the situation though. The only time that is invoked is when the child is in custodial interrogation.
Correct.
If that child comes back on their own and says, knock, knock, police officer, I want to talk. I got something to say. They're not under custodial interrogation.
I would argue if they're at the law.
And that's what the courts are for.
Yes,
That's what the courts
that we would agree to disagree, and I think it would depend on what a judge said. But if you're in a police station, a lot of times it's custodial.
Right, and sadly, Delegate, I will mention on the Joppatown shooting, sadly, a very sad situation, but there was nothing that stopped law enforcement from asking questions about the gun, because the law specifically includes exigent circumstances, and that would have been an exigent circumstance. Isn't that so? The Vice Chair.
It would have been so, but that statement could not have been used for the advantage of the child at a trial. It's only used to get the exigent circumstances, and that's it.
Exactly.
Yep.
Yeah, exactly.
What does you called on me, right?
Yes, I did.
What does an attorney tell an adult who has been in custody and the police are asking them questions?
What does an attorney tell
That depends.
He tells them not to talk,
but I will
not
say,
to answer any questions.
But I will say this, Delegate Davis, in that situation, the attorneys typically met in person with the person. They have background information. They're evaluating the full picture. In these cases, the law enforcement is contacting a phone number that they're given. There's an attorney on call who does not know the background of the juvenile, doesn't know anything other than what law enforcement is telling them, and then when they speak to the juvenile. So a lot of times, yes, a defense attorney's going to say, don't speak to the police. Sure. But I've run into situations where defense attorneys say, you know what? Let's speak to the police. Sometimes the defense attorney says, as long as I'm present, let's speak to the police. So I think there's different situations involved in each case.
I also think once an attorney has been contacted, and to go back to the situation where they go home, an attorney's been contacted and is now representing for this purpose their client, the Sixth Amendment has been invoked. So I don't think we can then talk, when they come back, I don't think we can then talk to him without contacting that attorney, and he's going to say they're not talking. So, and I don't think juveniles are as strong-minded sometimes as adults to be able to say, I understand you're telling me not to talk, but I'm going to talk, right? I think I should talk. And I don't think we can talk to them after they've gotten represented by counsel and they come back without calling the lawyer first. I just don't.
Seeing none, that concludes the favorable panel for House Bill 449.
Thank you, Madam Chair.
Thank you.
Thank you.
Good to see you. Have a good night.
All righty. Now we're going to hear the unfavorable panel, of those in opposition. I do not see Reverend Tillman. I do not see James Dole. Oh, I see James Dole. Come on down. I do not see Zaneet Charbry. Keith Belotra, Keith? I thought I saw, oh, okay. So we'll have Kimberly Watts, Allison, oh, that's right, and Kelly Quinn. Frank Piniella. And virtually, we'll have Aubrey Edwards-Luce. She's gone? Okay, all righty. So I think we have everyone. James Dole, Kimberly Watts, Kelly Quinn, and Mr. Piniella. Whenever you're ready.
Madam Chair, I guess I can get us started. James Dole, for the record, representing Human Rights for Kids. We are vehemently opposed to House Bill 449, in part because it's really an attack on the U.S. Constitution. What the proponents don't like is that it's not that they don't like SEPA, it's that they don't like the U.S. Constitution and the protections that are outlined under the Fifth Amendment, right? Because if every single child in this country was educated about their rights, they would exercise them. Every citizen who is knowledgeable about their rights exercises them. And so they don't like the fact that the Constitution protects children from interrogations where they may make an incriminating statement. And so the fact that that is the case is why they want to tear down SEPA and make it easier to interrogate children. And part of the reason for that is that children are easier to interrogate. We get high rates of false confessions with children who are later proven to be exonerated. 87% of kids under the age of 14 who were falsely convicted falsely confessed to the crime. 57% of kids who are under the age of 16. And just to that point, I want to highlight one really important piece to this, which is that this notion that by having parents involved, somehow that is going to safeguard the child's constitutional rights. Well, folks may remember the Central Park 5 case, right, where 5 black teenage boys were convicted. Some of them ended up in the juvenile system. Many of them also ended up in the adult system. And one of the children in that case had their parent with them, who actually urged them to talk to the police. And that child falsely confessed to the crime. And that is because parents don't always know their constitutional rights. When the stakes are this high, right, when we're talking about the loss of liberty and a child's liberty, there is no substitute for a defense attorney. And I promise you this, everyone on this committee and those prosecutors back there with the teenage children, if their kids were arrested, I promise you they would be telling them, exercise your Fifth Amendment rights. Any lawyer with their salt would say that to their children. So we urge a non-favorable vote.
Thank you. My name is Kimber Watts. I'm an attorney with the Public Defender's Office. I'm currently the chief of our Forensic Mental Health Division, although I've been representing kids for over 25 years. I'm also a resident of District 10 in Baltimore County. I disagree with the gentleman from Carroll County's reading of the law. The plain reading of the statute, well, the bill says that notwithstanding the requirement of this section, a law enforcement officer may conduct an otherwise lawful custodial interrogation if the child's parent, guardian, or custodian consents to the interrogation without that child's consultation with an attorney. That is unconstitutional. That does take away the child's ability to determine for themselves whether to consent to that interrogation. I also ask you to consider some other problems with this bill. It doesn't include a requirement of the police to tell the parents what charges they're looking at. It doesn't require them to refrain from deceptive police interrogation tactics. It doesn't require them to tell the child's parents where their kid's going to go after they get charged. Are we detaining them or are we not? I have manned the hotline a number of times. I've helped write our scripts. I can tell you it is not the case that we just blanket say, be quiet, don't talk to them. We do get their background information. I mean, these calls last at least a half an hour. That's what we're doing in that time. We're talking to the kid to get their information and to help them understand what their options are, and to be able to give them good counsel and advice. And ultimately, the question that we ask them is, do you want to talk to the police? We don't tell them what to do. They tell us what to do. That's the bottom line. I'm happy to answer questions.
Hi, good evening. I'm Kelly Quinn. I'm the Managing Director of the Choice Program at UMBC, a member of the Maryland Youth Justice Coalition, a D46 voter. We respectfully oppose House Bill 449. I've got a lot of words on my screen. You've heard a lot from us today. You know, what I'm just going to say is that Miranda rights are children's rights, are constitutional rights. Kids can be intimidated, scared, and vulnerable when they're being questioned by adults. They should have the fundamental, foundational right to an attorney. Stop. Thanks.
Good evening, Madam Chair, Madam Vice Chair, and members of the committee. My name is Frank Patnell, and I'm a senior policy advocate with the ACLU of Maryland. Also speaking on behalf of the Maryland Youth Justice Coalition. Many of our members were just here for the last bill. First, I want to thank you, Madam Chair, for sponsoring this bill, the Child Interrogation Protection Act in 2022. And thank you for the committee for passing it. And everything else has been said, so I think the moment you've been waiting for is me too.
Yes. Yes, the vice chair. Mr. Dole, you're familiar with the current law that allows police to lie to children. Are you?
Yes, ma'am.
Can police lie to parents?
Yeah, they can lie to everybody.
Thank you.
Yep.
I'm sorry. Sorry, it's getting late, and that smile that Delegate Conaway just gave me says it all. Delegate Conaway.
Yeah, that's the we're going to have pizza tonight smile. So, to the third witness across from me, yes, and you're paying, by the way. So you're saying that a lot of times when the juveniles are charged, they don't know the charges that they're facing? They don't know how much time they're facing?
Not necessarily. So I can tell you from my experiences on the hotline, the first question we ask the police are what charges are being considered. Sometimes they say, well, we don't know until we talk to the kids. Sometimes they say, well, we're arresting them on a warrant for whatever. So they certainly know. Sometimes they'll say, well, we're looking at this. And if we charge him with this, then we're going to release him to his parents. Other times it's we're looking at this, if that's what we charge him with. then we're going to have him ask for him to be detained.
Well,
Does that answer your question?
I would note on that, which may or may not be true. They might say they're going to release you, but after they talk to you, they decide, based on what you said.
Yep.
Now, okay. And what about the part of not being truthful to a juvenile suspect? I didn't want to say lying to them, but.
So nothing in this bill prevents the deceptive police tactics, interrogation tactics that one of your colleagues referenced. And I think that that's really important to note that, as Mr. Dold said, the police are, frankly, this is kind of frustrating to me. The police are literally the only people in the system that are allowed to lie. Like, I can't do that without getting in serious trouble. The judge can't do that. The prosecutors can't do that. But the police officers can give false information to induce someone to confess. And while I can cross-examine them about that, like, they've done nothing wrong. And so that's a thing that can happen. And this bill would allow that to happen without the kid being able to talk to an attorney to know that.
Thank you so very much.
Members, do we have any other questions? Seeing none, that concludes the unfavorable panel for House Bill 449, and that concludes that bill hearing. We're going to move on to Delegate Johnson. House Bill 481. Excuse me. Delegate Johnson, I don't remember seeing you in this committee very often. Welcome.
No, Madam Chair, actually, this is a kind of a new experience for me.
Well, let me tell you how it goes.
I've kind of witnessed it a little bit today. And I do have 2 virtual witnesses.
Okay, great. We'll call them up. You have 3 minutes and everybody else has 2. And Christina Riala, I think I messed up her name. And Robert Garza, are they both available? Okay, Robert's available. You all can start, and then we'll bring Robert on. Thank you.
All right. Well, I was going to say good afternoon, but I have to say good evening now. Madam Chair, Vice Chair, members of the Judiciary Committee, you have had quite a day today, so I'm going to try to make this brief. For the record, I'm Delegate Steve Johnson, here to present House Bill 481, Family Law, Denial or Interference with Visitation Rights. House Bill 481 requires, rather than authorizes, a court to order visitations to be rescheduled in a manner consistent with the best interest of the child and subject to certain requirements. When a court finds that a party to a custody order has unjustifiably denied or interfered with visitation. The additional visitation must be of the same type and duration as the original at the time the other parent chooses, and within 2 years of the court's determination. For example, if a parent denies the other parent visitation over Christmas one year, the court could require that the interfering parent provide and make up visit for Christmas at the time that the denied parent selects, within 2 years of the court's ruling. This bill is important because it recognizes that children need their parents. They need both of their parents. And that the denial of visitation by a parent can have lasting negative effects. Children benefit from a healthy, ongoing relationship with both parents. And when one parent unfairly interferes with the relationships, it disturbs their emotional development and well-being. The goal of House Bill 481 is to prevent one parent from using their authority to manipulate the custody arrangements and leave children in the middle of conflicts that are not of their making. This bill seeks to ensure that kids have consistent access to both parents so long as it's in a safe and healthy environment. At the core, this bill is about fairness to both children and parents. The bill aims to discourage parents from violating court orders. I want to repeat that, from violating court orders by interfering with visitation schedules. In some cases, one parent may deliberately withhold visitation as a way of punishing the other parent or gaining leverage in custody disputes. By making it mandatory for the courts to reschedule visitation when interference is found, the bill ensures that children are not left without their right to spend time with both parents and holds parents accountable for honoring custody agreements. Furthermore, this bill addresses the clogging of court dockets and misuse of child protective services. Disgruntled parents make false claims to CPS in an attempt to manipulate the system, resulting in unnecessary investigations, draining resources, and delays in addressing the dangerous cases that require their attention. House Bill 481 seeks to alter parents violating court order custody agreements. I respectfully ask for a favorable report on House Bill 481.
Yes. Thank you. Thank you, Madam Chair, Vice Chair, members of the committee, for your service and for the opportunity to speak today. My name is Brian Fitzgerald. I'm a father, and like everyone here, I'm also someone's child. This is one truth that crosses every party and every belief. Every child understands love is time. Not legal language, not explanations, just time. When a court issues a visitation order, adults see a schedule, but to a child, it feels like a promise. You matter, and your time with both parents is protected. That promise exists only because a court has already determined the child's safety. The problem this bill solves is simple. When that court-ordered time is taken from a child and nothing restores it, the system teaches that child that promises made to them can disappear. While adults wait for hearings, motions, children don't understand the procedures. They ask themselves, did I do something wrong? Am I the reason they're gone? Time taking time back is a bill built on a simple principle. When time is taken from a child, that time belongs to the child and it should be restored. The bill doesn't punish parents, doesn't pick sides, simply makes court orders meaningful and protects children from the emotional cost of adult noncompliance. I respectfully urge you to support time taking time back for every child in Maryland whose time deserves protection. Thank you.
Thank you. I'm going to go ahead and go to our virtual panel. They're favorable, unless you have any objection, Delegate.
No, that's fine. Thank you, Madam Chair.
Okay. So Christina Rilo?
Yes. Can you hear me okay?
Yes, we can hear you.
Great. Good evening, Madam Chair, Vice Chair, and members of the committee. Thank you for the opportunity to share my testimony with you today on behalf of countless families in my state who have adversely been impacted by unsubstantiated unilateral withholding and child custody interference. My name is Christina Rilo. I'm a Baltimore County resident and a state of Maryland employee with joint legal and physical custody of my 4 children. I'm here today in support of Maryland House Bill 481 based on the positive outcome that my children have experienced resultant of a similar plan of action being implemented at my modification of custody settlement hearing. I've had experience with family court over the past 10 years, successfully seeking their assistance in matters pertaining to my divorce, contempt filing, and most recently for modification of custody. To protect my parental rights, I've resorted to funding these efforts by means of a home equity loan. In 2016, when I initially filed for my divorce, I chose to file for joint and physical custody of my children, motivated by my belief that it was in my children's best interest to be able to maintain and cultivate a quality relationship with both of their parents, regardless of our individual differences. While court-ordered custody schedules are expected to be adhered to, parents are also expected to successfully collaborate for deviations as needed. When collaborative efforts are unsuccessful, it becomes apparent how few supports are in place for rule followers and survivors, and appallingly how few consequences are in place for abusers. Ultimately, the ones that are who pay the greatest price are our children. Maryland House Bill 481 presents a solution to ensure restoration of the parent-child bond following unsubstantiated unilateral withholding, while simultaneously disempowering an abuser's efforts to intentionally damage a child's bond with their equally fit, willing, and able parent. I thank you for your time today, and I humbly seek your consideration in support of this bill in light of my testimony.
Thank you. Mr. Garza, Robert Garza. Is he there? Okay. Okay, Mr. Garza, we're going to go ahead. Members, do we have any questions? All right, I had a question, but I'm not even going to ask it now. Because Mr. Fitzgerald, you submitted written testimony, and that's helpful with the judiciary's testimony, because they're saying that you have to use the best interest of the child standard, but you emphatically said that this is the child's time. Is that correct?
Yes, ma'am.
Okay, thank you. Mr. Fitzgerald, you submitted Mr. Garza written testimony, and
Yes.
okay, are you ready to testify for 2 minutes?
Yes, sorry about that.
That's okay, you may begin.
My name is Robert Garza. I'm testifying on this bill in favor of it. Sorry, I was running. What this bill does is when you go through a false allegation and you finally get, there is no finding of abuse or neglect, that time is returned trying to
Mr.
catch my
Garza,
breath here.
Take a minute, yes,
When you
take a
return the
minute.
child, you shall return the time, and the same type of time, and the same exact amount of time. In this case, if you miss a Christmas, you get that time returned, and you get 2 Christmases in a row. It stops the allegation from being made, but it doesn't stop a real allegation. And that's where this bill comes into place. Sorry. This bill passed in Texas. It went through unanimous, bipartisan the first time, and it protects 30 million Texans today. After it passed Texas, it went through North Dakota. North Dakota passed it, did double the time back. Again, it's a law in North Dakota, and when it went through those 2 states, that's when a lot of the other states wanted this bill, because it stops the bad behavior before it starts. It returns those resources back to the DA. It returns the resources back to CPS and to the court system just by doing this one act alone. And sorry. It fixes the families, because when you go through this, I went through 43 plus false allegations, and every time my ex weaponized the system, it took those resources away from all those agencies, and this would return those resources without any fiscal note and without anybody getting reprimanded.
Thank you very much, Mr. Garza, and especially in the being winded. I appreciate your testimony. Members, do we have any questions? Seeing none, thank you very much, everyone, for your testimony. Thank you, Delegate.
Thank you, Madam Chair.
Have a great evening.
You have a good evening as well.
Thank you.
We're going to move on to Delegate Pippy for House Bill 475. Oh, no, you're right. I apologize. My apologies. I saw it, and then I looked away. Lori Ruth, unfavorable, and Brendan Madden, unfavorable testimony.
We're going to have Mr. Madden go first, if that's okay.
That's fine. Thank you.
Good evening, Madam Chair, members of the committee. I am Brendan Madden here on behalf of the Family Law Section Council of the Maryland State Bar Association, and we urge an unfavorable report on this bill. The issue of resistant children, of custodial interference by a parent, they are some of the most difficult problems that certainly practitioners face, that the courts face, and we know that families face. But this bill is not the remedy to that. It is not a child-focused bill. It is parent-focused. It mandates a heavy-handed, one-size-fits-all solution to, again, one of the most difficult problems that we face in the family law sector. It demands what we do in family law is individualized assessment of each family and each child and carefully tailored remedies. And make-up time under the current statute 9105, the family law article, is permitted, and it's a common request, and it is often granted. But like all things with child custody, it's not an absolute. Makeup time is not always practical. It's not always appropriate. And even where it is, it may not be appropriate to offer, to mandate all of the time be awarded back, and certainly not, as this bill would do, mandate that it be double the time missed. It makes it, and these mandatory requirements make it impossible for the bill to do what it says in the text, that the ruling should be consistent with the best interest of the child. If a judge is required to order double the time at a time that the other parent chooses within a broad 2-year span, it's impossible to make a decision in the child's best interest. It is, and I heard from the witnesses, I don't know the family law of Texas or North Dakota, but I know the family law of Maryland. And that's not consistent with our decisional law, and it's not consistent with our statutory law, which is based on the best interest of the child. So for that reason, MSBA urges an unfavorable report.
Thank you. Ms. Ruth?
Good evening, Madam Chair, Madam Vice Chair, and members of the committee. My name is Lori Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence. I want to just echo everything that Mr. Madden just said. I could not agree with him more that this is not a child-focused bill. It does not. It pays some lip service to the best interest of the child, but to remove all discretion from the court is really not how we handle family law in this state. This bill is punitive. It's not remedial. We do not believe in cookie cutter law, cookie cutter decisions, and the judges need to be free to understand what's going on in that particular family on a case-by-case basis. Approaching this from the domestic violence lens, I cannot stress to you enough how ripe for abuse this bill is, and I can come up with myriad scenarios where an abuser is going to be able to upend his victim's life by being able to dictate when. I did have a very polite conversation with Delegate Johnson's aide, and I said, I'm just going to make up a hypothetical right now it's not even hard for me, that this is going to come back and harm the survivor, because if she withholds the child for protective parent purposes, for safety purposes, but is unable to prove that in court, and a judge says it was not justifiable, the judge then has to give double time to the other party, whether the child was in an unsafe position or not. And then also the abuser gets to pick when he or she gets the makeup time. And in my hypothetical to his aide, I said, so he knows that I'm getting married on June 15th and that our daughter is going to be the flower girl in our wedding. And under this bill, he gets to say, thank you, Your Honor, I'm going to take June 14th through 17th and just to make sure that I cannot have my child at my wedding. And that's just one. I could do 20 more, but I urge an unfavorable report in this bill. Thank you.
Thank you. Members, do we have any questions? Delegate Conaway.
Thank you, witnesses, for coming in to testify to the person that just got finished testifying. So in your example, let's say if your significant ex-other was supposed to have the child for Christmas and you don't send the child for Christmas. Now, your ex gets double time and they know that you're getting married in April or whatever, and they say they want from the 15th to the 17th. That's to get back at you, right?
Yes, exactly. That's my point. It's to control
I
me.
understand all of that. I understand that. Okay. Why did you miss Christmas?
Because in my hypothetical, the child came back from the alternating weekend visitation and said, my stepmother locks me in my room and they don't feed me. I'm very hungry when I come back. I, as a protective parent, say, I don't know what to do about this. I need to call my lawyer. I'm not sure what to do, but I'm not going to send the child the next weekend. And I will go in front of the court for a contempt action where I can explain what happened. But all of that, everything my child told me is hearsay. So I have to go in front of the court, usually unrepresented. We know that 80% of family law court cases have an unrepresented or two unrepresented people, and try and explain how I made that decision, that I was trying to make sure that my child was safe before they went back to that house.
Stop right there. So you explain that to maybe a judge or something?
Yes.
And the judge says, I don't buy that. I don't go for that. So you're gonna have to give up the double time.
Right.
And then your significant ex says, yes, I want the 2 days when she's supposed to get married, right?
Right.
But that's a part of your decision-making process when you made the decision to go to court, right?
Right. When I made the decision to withhold the child for safety reasons.
Yes, so you knew that was a part of the process, right?
Well, under this bill, yes, but under our bill now and how lawyers advise their clients all the time. And when you work with domestic violence survivors, there is a lot of this that goes on. And there's a lot of manipulation.
Suppose it's not domestic violence. Suppose I just hate your guts. How about that? How about it's not the domestic violence, okay? So we just don't get along.
That's fine. Suppose my ex, the father of my children, hates my guts.
Yes.
That's not child-focused either. For him to then try to ruin my life at my wedding. And so, you know, these relationships are even when there is zero physical violence, maybe not even emotional. I don't see that very often, but you know, maybe that's the case. If there is that level of hatred and volatility, the most important thing is to be child-focused and not have a cookie-cutter recipe. It might not be in the best interest of that child to have double time with the other parent for reasons entirely different from being a survivor or that power and control dynamic going on. Maybe that child just doesn't do well at that house because there are 4 other children, or because there are no children, or because they love their dog and don't want to be away from their dog that long. The judge can hear that at the contempt hearing under current law and make a best interest of the child decision with all those facts in front of them. This does not allow that. And it could punish the child even worse than the parent.
Right, but if your ex comes back at you and takes those 2 days, it doesn't hurt the child, it hurts you. Is that right? Would you agree with that?
No.
No, you wouldn't. You would say that hurts the child?
I think it depends on the case.
You gave the example. We were talking about the example. So
I think my daughter,
2 days when you're supposed to be getting married.
I think my daughter would be devastated when she has her flower girl dress and she knows she's going to be a part of my lovely wedding, to all of a sudden be told, oh, sorry, you can't be in the wedding. I think that would be devastating for a child. And you're giving that power, you're taking the power away from the court to say, you know, right now, the guy might say, or the woman might say, you know, I want that June 15th date. The other party is there to say, that's my wedding weekend, Your Honor. Please don't order it then. I've lost, and you're going to give him makeup time, but that's my wedding weekend. Under this bill, the judge can't do that. The other party has all of the power. And in a power and control and coercive control dynamic, that's really, really dangerous and damaging.
Well,
and the children suffer too.
Thank you for your testimony. Don't get me in too much trouble, but I appreciate that you understand that you made a decision in the beginning. So I appreciate that. Thank you very much.
Thank you.
Just briefly, because this is sort of like black letter law, the statute, what I was wondering is, you know, usually when there's custody fighting or there's contempt orders, you can file a motion for an attorney for the child's interest, or you can, you know, the parties can try to negotiate through the Office of Family Court Services, and those are not exactly in statute, but they're more likely to be in the rules. And you know, the rules of procedure in domestic cases, and some of the things that they've done, you know, as far as you know, standard interrogatories, requests for documents. So I was wondering if you think that this, because the way the bill is written, it's not going to allow for some of those other things that can be done in contempt hearings, or when there's, you know, somebody wants a change in custody, where you can get those outside forces in there to say, hey, kind of explain what's going on. So I'm just curious as to your thoughts on that.
And I think you're right. You know, the Family Law 9105 is kind of a weird part of our custody law. It's just, it's already somewhat inconsistent with how we handle custody in every other respect. It's kind of like a contempt hearing, but it's not a contempt. So yes, it's often when someone files a motion for unjustified denial, it comes in the posture of a contempt where it's usually a quicker, shorter hearing. And the court is really looking at this very narrow question of, was the denial unjustified or not? They're not always, they're not upfront thinking about the full best interest factors or anything like that. So there's not an opportunity to get a BIA, a best interest attorney, if you wanted one.
If we pass this, that would be a problem. Is that what
I think it would exacerbate what is often already a problem with this existing statute, where parties are going in without the resources of the courts. You're correct, except the punishment would be doubled and mandatory.
Well, let me ask you this. Could sui sponte, the judge say, hey, I want you to, go to the Office of Family Court Services? Could he order it under the bill if it was passed as a statute?
I don't think a judge could. I think a judge could have them in front of them the day of the hearing and say, you know what? If you're all right with it, I want you to go down to settlement court and see if Judge so-and-so can help you settle this case. And it is a fair point to say that the witness, Ms. Ryler, who testified, she settled it. And I had a conversation with her earlier in the week, just coincidentally, and they worked it out so that she got back what she felt she had lost, and she said it's been working well and fine, and I congratulate them. But I don't know that every court or even the majority of the jurisdictions send you to settlement court mandatorily for a contempt or a 9105 interference with custodial time. And so I don't think that you have the full array of opportunity at all, because as Mr. Madden said, it's very narrow.
Would that be a good amendment for this bill?
No, I think this bill is terrible for many, many reasons.
I'm trying to save my fellow delegate.
And that's just one, that's just one comment, but thank you.
And I think the court could do that. I mean, as the bill is currently written, they can order any relief they believe appropriate. The specific items delineated in the bill are examples. I mean, as we know, it's usually limited to those, what the court actually does, but they could refer someone to a settlement judge if they felt it appropriate.
Okay.
Probably, but.
Members, no further questions. That concludes this panel. And now it concludes our testimony for House Bill 481. Well, is Denise Grimes here? Okay. So we're going to move on to Delegate Pippy. Thank you, Delegate Pippy, for your patience. House Bill 475.
Thank you. Madam Chair, Vice Chair, committee members, appreciate you being here late. I will be quick. Delegate Pippy here in support of HB 475. This bill is very straightforward. It just prohibits the Department of Juvenile Services from hiring individuals that have been convicted of kidnapping, manslaughter, murder, rape, sexual offenses, child abuse, sexual abuse of a minor, felony offenses, assault in the first degree, assault with the intent to murder, assault with the intent to rape, assault with the intent to commit a sexual offense in the first degree or second degree. And you say, well, why are you putting this bill in? So I put the bill in last year. And what happened immediately after I put the bill in last year, it obviously didn't pass, was that we became aware that Department of Juvenile Services in Maryland had actually hired someone who was convicted of murder. They actually hired someone who was convicted of other offenses, serious assault with a weapon. There's also a DGS employee who was indicted on 57 felonies related to sexual abuse of minors. There's been several news reports of individuals being placed in care of sexual offenders. Look, this is a very straightforward thing. I think people that are entrusted with the care of our youth should have a clean background. And the current law that's in place doesn't actually prohibit the DJS from not hiring individuals with these crimes. So last but not least, the state of Delaware and Virginia both have laws on the books that prevent certain individuals or certain offenses in their backgrounds from working with children. I think this is very reasonable considering all of the things that have come out in the last 12 months as people, DJS, being in care and custody of minors, with sexual offenses. I mean, there's just a whole lot going on. So with that, I ask this committee for your due consideration, and I appreciate a favorable on the bill. Thank you.
Thank you. Members, do we have any questions? Seeing none, I'm sorry, Delegate Valentine. I did look that way, I just didn't see.
I didn't hit my button quick.
Oh, okay.
Thank you, Madam Chair. Thank you for bringing the bill, Delegate. My question to you, and I think you touched on it, I know there's nothing in statute. I'm looking at the one, does DJS have anything internally to prevent the hiring? Because there's nothing listed here. They provided no testimony.
Yeah.
They didn't weigh in one way or the other. In fact, I'll let you get to the answer in a second. Did the only opposition testimony, did you see the opposition testimony? It's the League of Women Voters.
Yeah.
So I was kind
of
curious to see DJS's stance on this.
Well, I think their lack of weighing in says it all. As this committee knows, the secretary of DJS was removed finally, and there's a new secretary of DJS. Look, there's been a string of audits that have come out that have found in certain agencies or state they actually failed to do background checks altogether. And then it was found that individuals working currently at DJS had convictions ranging from murder up until serious assaults with a weapon. Obviously, this committee knows that there are former DJS employees that have been indicted on dozens of felonies related to sexually abusing boys in DJS facilities. So I think this is reasonable given the fact that there have been some very high-profile situations in Maryland that have come out, and I just think this cleans it up a little bit. So I'm hopeful that DJS will be in support. And I think reasonable background checks and eliminating individuals that may have some questionable histories that are in care and custody of our children, I think is a very reasonable thing to do. So thank you for the question.
Thank you, Delegate. Thank you, Madam Chair.
You're welcome. I'm looking at the League of Women Voters testimony, and I see why they opposed. Would you be interested in any type of amendment that at least gives a time frame in which the crimes were committed? They were concerned about particular crimes that were committed when a person was a juvenile, and that, as you well know, I'm assuming that you know, having been in judiciary, their point is that some of the credible messengers that exist are actually individuals who have been rehabilitated, and perhaps in their youth they committed a particular crime, and now they are advocates and working hard with individuals to assist them so that they don't go down the same path they went.
Sure.
Would you be interested in any type of amendment in that regard?
I will say this, I am certainly open to the will of the committee. And if the committee finds that there's some amendments that makes this palatable, I'm definitely for it. I understand that people, well, and the other thing too is that when you, generally this committee I'm sure knows, when you commit an offense as a juvenile, usually that record is expunged. And so I think this bill mostly deals with individuals where crimes have been committed as adults. I think that's a different ballgame generally, but I'm open. If this committee is willing to work with me, certainly willing to work with you guys.
Great.
Thank you.
Thank you so much. Members, I see no further questions. Let's go on to our next bill. Thank you. That concludes our bill hearing for House Bill 475. We're going to go to our next bill, Delegate Simpson, House Bill 412. And Delegate Simpson,
yes,
I see that you have a panel, Christopher Dews, Dewan Burton, and Amy Vora. Let's go on to our next bill. Thank you. That concludes our bill here.
Thank you very much, Chair, and my Judiciary family. I know not all of you have been here for the last 3 years that we have introduced this bill, so I'm going to make it very clear what the goal of this bill is: to ensure that driver's license suspension is only used when appropriate and necessary to serve the best interests of the child in compliance with the federal code. Our goal is intended to reduce the number of errors. As I've shared in this committee before, we're talking about 20,000 suspensions a year, 10,000 in error with people who are actually paying child support, or they have custody of their child, or for some other reason. So this bill was introduced in 2024, 2025 to address that significant number of licenses that were suspended in error that led to people losing their jobs, which of course the whole point is if you can't work, you can't drive, how are you supposed to work? Loss of income, loss of car insurance, missed work, and the negative impact that this has had on the child. So the bill was revised last year to reduce that fiscal note by utilizing the department's existing processes. So this doesn't change anything. Let's be clear. They already are required by law is to have a notification. That notification still exists. The letter, I think there was something in there saying, well, if we have to notify them by electronically, that's going to increase the cost. Well, if you don't have the address now, it doesn't increase or change the cost. If you don't have that, those things are taken care of by regulation. They're taken care of by policy. You know, every state agency as far as the notification. And being able to, most of us would agree that people are less likely to change their electronic address than they are to change their physical address. It continues to give them the right to investigation, but it adds hopefully things that all of us would agree, which is if they have physical custody of the child, then their license shouldn't be taken or suspended. And if they are actually paying child support, then we don't think that even if they have some arrears, if they have an agreement, they're paying that arrears, they shouldn't have that. It defines when it's appropriateness. As we said, this is in compliance with federal funding. We've checked other states. With all of the updates and things like that, we believe that this bill will reduce that error rate and that it will actually provide additional time and energy and resources for the department to pursue support for children because they will not be distracted by other cases. I urge a favorable report. Thank you.
And I'll go next. Good evening, committee. My name is Ami Bora. I'm the Advocacy Director for Family Law at Maryland Legal Aid. We urge a favorable report on HB 412, which will ensure that driver's license suspensions for non-payment of support is not used automatically, but instead only in cases where a parent has the ability to pay support but is choosing not to do so. Now, at Maryland Legal Aid, we've represented countless parents in child support cases, and we've seen that historically Maryland has overused license suspensions compared to other states, which has led to devastating consequences for families. Without a license, a parent can't get to work. If they can't get to work, they can't pay their child support or even take their child to school or have visitation with them or take them to appointments and activities. We passed important reforms back in 2025, but Maryland still relies on an automated system that is set up to indiscriminately refer parents for suspension as soon as they reach 120 days of arrears, because there's no human review on the front end of whether a given case that is in arrears is appropriate for suspension. And so we've seen cases where parents' licenses are suspended even when they need their license for work, even when they're disabled, and even when custody is actually changed and they've given notice of that change to the agency and that the child is actually residing with them. In all of these cases we've handled, licenses were still erroneously suspended. Now, the previous panel also talked about how one-size-fits-all, policies, the previous family law panel talked about that one-size-fits-all policies, cookie-cutter solutions. That's not appropriate for family law, and that very much holds weight when it comes to driver's license suspensions and their impact on families. This bill closes the gaps. It defines when suspension is and is not appropriate, and it mandates that the agency individually review delinquent cases before referring them to suspension to make sure that that's appropriate. In this modern age, not every aspect of every process needs to be automated. When the potential consequences are so damaging, a human touch is required to make sure that powerful tools like license suspensions are wielded precisely and not chaotically. And so for those reasons, we urge a favorable report on this bill.
Yes, Christopher Dews representing the Center for Urban Families and Out for Justice. Just want to refer you to Legal Aid's written testimony, just some comparison to other states. And one that stood out to me the most was in 2024, Wisconsin had 3,733 suspensions compared to Maryland's 20,512. There's all sorts of other examples in here. I don't have my list in front of me, but comparably, we just over-suspend. And again, the purpose of this is just to determine and set in statute when is it appropriate, when is it not appropriate, and which is already in accordance with federal law. I also want to highlight that previous years, I want to say last year, I know there was slight changes in the language, but I believe this bill to the state would have cost about $137,000, $400,000 if you include the federal numbers. But I think 66% is paid off by the feds, and then the last 33% is paid off by the state, which would have been roughly about 137. However, this fiscal note is about different. And so we're somewhat confusion about that, but I do know that there is some conversation happening with the department to try to work this out. With that, I am happy to urge a favorable report. Thank you.
Move on to, let's go ahead in the name of efficiency, go with Ms. Burton, and you'll have 2 minutes to testify, please.
Good evening. Thank you, Delegate Simpson and Chair for bringing this bill forward. I'll be brief, but DeJuan Burton, Out for Justice Deputy Director. We've heard already about what this bill does. I just want to clarify or reiterate that this is defining when it's appropriate. As an Out for Justice leader, we have supported and helped to advocate for folks who are struggling with, child support arrearages, and we've seen when we were calling, the Child Support Administration, not getting responses and trying to mitigate and provide information around why this is not appropriate for someone's license to be suspended. In my own personal experience, I'll talk about, my son's father, despite having his custody of his kids, and he, routinely faced license suspension. And so when we tried to call the Child Support Administration, there's just a license suspension merry-go-round, and ultimately it meant that I had to bear the brunt of managing transportation for his other kids and the child we share, as well as trying to make sure that he was able to get back and forth to work. I just want to also reiterate that this license suspension is just one tool that the Child Support Administration has and their toolkit. Wage garnishment, there are other tools of enforcement that they have, and so we just ask that you find us a favorable report to ensure that we can reduce the barriers that folks continue to have year after year. So thank you. I'll pass it to the next person.
Thank you. Is that Mr. Williams?
Yes, good evening, Chair.
Good
Thank you
evening.
for having us being able to speak. My name is Jonathan Williams. My personal experience with license suspension, I did not have even the chance to make my first payment and my license was suspended. We went to our hearing in February of that year. Afterwards, we were told that, my son's mother and I, we were told that before the judge has to sign off on the order before I could pay. So 7 months goes by. We're told that, you don't have to start paying until the order comes through. I go to get in my car to work because I was driving Uber at the time, just to make extra money to pay the child support. I didn't have a problem with paying the child support. I had a job, had a house. I get in my car, turn the app on, license is suspended. I call them, they say you owe $6,000, $7,000, $8,000 in back pay before I was even able to make my first payment. And nor was I notified that the order had been signed. That's how I found out the order was signed that day, license suspended that day. So now I'm in debt. My job at the time required me to drive outside of the Uber. So I'm going back and forth, trying to get my license situation taken care of. There's nobody to talk to. When I did talk to someone, because I had arrears, I was always told, you got to clear that up first before we can do anything for you. So as this is going on, can't afford my mortgage, losing my job because my boss is like, all right, you got to drive to Jersey. We need you to drive here. I don't have a license. So now, fast forward a couple of years, I lose my job, foreclose on my house, in debt. All before, all this snowballed, and I wasn't even, just because I wasn't able to make that first payment because of the arrears in the license suspension. that came out of nowhere. So, but that's it. Thank you for your time.
Thank you, Mr. Williams, for sharing your story. Quick question. So did they ever correct? Were you able to get anything corrected?
So that's the thing. They weren't concerned about correcting anything. They didn't want to hear anything from me because I had those arrears.
Okay.
Whenever I did talk to someone.
I understand. Okay. Members, do we have any questions? Delegate Taylor and then Delegate Conaway.
Thank you, Madam Chair, and thank you, Delegate Simpson and the crew over there for bringing this bill back again this year. Just a few questions. We worked on this bill a few years ago together. Is this the exact same bill as 2024?
Yeah, we've actually cleaned it up to make sure that
It's not the exact same bill.
Last year, we moved it all around, and it's the exact same thing in which we're just taking, they already have a letter, they're already sending it out, just as those two other things there.
Okay, let me ask you another question before you continue. 2025, is it the same as the 2025? Is 2025 the same as 2024? The intent is the same, but the language is different.
Right, the 2024, we actually were trying to put this tool into the courts. The courts wanted it, and we were trying to put it into the courts.
Right.
And they came out with a $2 million bill. So not the courts said they could do it for free with existing, but the department had said that they were gonna need all sorts of additional workers. So that's why we changed our ways, and we said, okay, we will use their existing resources and we will use the existing processes, and then we are simply going to define when it's appropriate and say, these are the conditions that we found with the errors that it should not occur. And so that's what we, with the advocates and with the people who've had experiences, that's where we came up with the language.
And this year, in 2026, the intent is the same.
Intent is the same.
But now this bill is basically just does two things, right? It adds notification.
Electronic notification.
Right, and it adds the ability for someone to have clarity as to whether or not this is a justifiable suspension.
Correct, and says,
That makes sense?
says these are the conditions upon which they can investigate, that I have my child and, I'm already paying support, so.
Okay, and then in 2024, the fiscal note was?
2 million, 2025, 400,000. And so for the same bill, this year.
Because we have tariffs now, I'm sure.
Yeah, there's tariffs on social workers. So now we have a $6 million,
Fiscal note.
apparently, bill, even though, once again, we are using their existing processes. We did not change. It's still the same thing with the letter and everything else, yes.
Right, except like electronic is now added,
The
right?
electronic is added, but once again, same thing if you didn't have a physical address, if you don't have an electronic address, then.
Thank you.
All right. Okay, I just wanted to make sure. I didn't hear that final part of the answer. Delegate Conaway?
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. Did I just hear you say the price for the bill went up from 2 million to 6 million?
Oh, no. 2 million was 2024 to put it in the court system. Last year, the final amount was 400,000.
And what's it this year?
5.9 million.
What, do you have any idea what the difference is?
No, because actually it gives the same number really gives the same number of staff in there. And actually, like I said, we really scaled down and made sure it was very clear that we were using existing processes. So the electronic was in last year's bill. The defining when it is appropriate was in last year's bill. It said, as a matter of fact, that in fiscal year 2026, $403,000, and said that they needed some more workers. And of course, said all of that was reimbursable. So I assume that the 5.9 must be reimbursable with the federal money too, so.
Can you get that information to me if it is reimbursable? And so you said it's 20,000 per year, but about 10,000 suspensions are in error. What are those errors?
As I said, from what we are seeing from our understanding is that the individual, when they've said, hey, they find out that their license is suspended and they contact the department and the MVA, is that they are actually paying child support. They have an agreement.
The kid is
So
now
how did
residing.
not
The kid is now, you know, whatever it might be that they have restored it.
In that situation, are you talking about where a person pays the state and the state distributes
No,
the
not,
money?
they were
or
already paying. Yes, they
were-
have been paying.
They have been paying themselves, but not through an agency?
No, they're in error.
Are they paying through an agency?
They're paying through the Department of Human Services through child support.
Okay, and child support doesn't have an answer as to why they have a 50% error
That's a
rate?
great question, because remember,
I'm trying to help you.
it is actually a great question, because actually the way the law is currently written, anybody who is in arrears, was 60 days. Now it is 120 as of the law that we passed last year. So as long as they are swimming in that pool, they are subject to having their license suspended with nothing out. I mean, they could be paying. They are subject to having their license suspended. That's the way the law is currently written. It does have, just like we said, you know, they send out the notification, they can do an investigation under certain circumstances and not have it, but still that's subject to what they determine. And that's where, like I said, the only way we were able to get the numbers is through the MBA. They're the ones that track how many licenses are suspended, how many of them are in error. And as we said last year, was about 9,000 is just a quick fix. 1,000 of them actually have to be scrubbed, and that's your cases with the insurance. So it looks like you've had multiple, suspensions, and they're losing or it's increasing their insurance.
If it was an error and you get that fixed, is that free, or do you have to
No,
pay?
actually, if you were driving on a suspended license, that is not expungible. So if you were driving, you already have, remember that when we went to court and did our field trip? Yeah, so if you were caught and didn't know, because that was the other thing, some of them, was used as locating them, that they didn't even know that their license was suspended.
Okay, thank you very much.
Thank you. Members, I see no further questions. So that concludes this panel for House Bill 412. We're going to move to
Thank you, Madam Chair.
our
can't leave.
Brandon Madden, who is on the unfavorable panel.
Oh, I do get the yes.
And thank you, Ms. Burton and Mr. Williams, for your testimony. Bye-bye.
Good evening again, Madam Chair, members of the committee. Brendan Madden, again, for the Family Law Section Council of the Maryland State Bar Association. I apologize for not having the opportunity to submit written opposition to this bill. I was tied up testifying on the cross bill in the Senate on Tuesday and wasn't able to modify our testimony there in time to submit here. But had we been able to submit that, we would have, it highlights our two concerns with this bill are the imposition of requirements that we think will possibly prevent the use of the suspension mechanism entirely. The inclusion of the free and conscious choice determination. That's the language, that's the finding that's typically made by a court for voluntary impoverishment, for contempt, for failure to pay child support. It is an evidentiary decision that requires, fact-finding, and it's not something that an administrative agency like the Child Support Administration is well equipped to do in the particularized field of family law and child support. We worry that having that as a threshold decision before the suspension, mechanism can even be applied to someone will, for the most part, prevent it from ever being used. Similarly, the notice provision, which sounds reasonable on its face, but the reality is a lot of obligors may never have provided electronic, an email address to the Child Support Administration. They may have changed it. And what that means is if by having this be a mandatory, threshold notification requirement, if they don't have an email, if they can't find the right email, they can't ever suspend a license. And there may be obligors who choose to withhold or not.
Sir, could you wrap it up?
I will. And, and DHS has not, to my knowledge, stated their position on the bill, but as the MSBA, we are concerned that restricting the use of this powerful enforcement tool may interfere with the collection of support and risk our access to federal funding that it relies on. So.
Delegate Conaway.
Thank you, Chair. Thank you for coming in to testify. What is this that you're saying about the email address? So who doesn't have the accurate email address?
So, and I believe that this was asked of the opponents as well, but if there's a requirement that the agency provide notice, written and electronic, to the obligor before they can implement the suspension.
Yes.
The obligor may have never provided an email address. So if they don't have an email address on file, they can't issue electronic notice. If the obligor has issued an incorrect email address, if they've changed their email address, then all of a sudden they can't even get past that basic threshold.
Well, let's slow that down a little bit. Let's say if you change your email address, right? Let's just talk about that one, the last one first. You change your email address. Isn't it your responsibility to let these people know that you've changed your email address so they can send you your appropriate documents? Wouldn't you agree with that?
I would agree with that. I don't know if the bill requires them to provide, and there may be another provision that requires them to update that, but if they don't, the question is.
No, but you said you would agree with it?
I would agree that it is, I would agree that it's the responsibility of the obligor to provide current contact information, yes. But if they don't, the bill doesn't provide a mechanism where DHS just says, well, we think they haven't given us current information. We think they're trying to avoid enforcement.
Okay, well, let me ask you an average prudent man question. Wouldn't the average prudent man think that if they don't give the appropriate information, they're going to get their license suspended, and then they're going to believe that if they get their license suspended while they're driving, they are subject to get locked up? Is that a fair assumption?
I'm not sure I can agree with that.
Oh, okay. Well, I was just talking about the average prudent man.
We see a lot of, I deal with the reasonable person a lot, and they are often very unreasonable.
Is not the average prudent man? Is that what you're trying to say?
Well, I will just say,
is that what you're trying to say?
Requirement that I'm more familiar with in the, at least at the circuit court level is in custody cases and child support cases, parties and the obligor is required to provide current.
But right now, we're talking about driving, which is a privilege, right? Is driving a privilege?
Yes.
Oh, okay. Thank you very much.
It is a privilege.
Yeah, I understand.
Thank you very much. I have one question. I don't know whether anyone else would agree, but it's pretty unusual that the bar would weigh in on the collection of child support. What section do you belong to, and what section are you representing?
I'm with the family law section.
So the family law section decided that they were going to weigh in on the collection of child support.
Well, I believe that this is the family law section. We consistently advocate for or against bills that affect custody and child support, and that includes the collection of child support. This is somewhat downstream for what many members of the section deal with on a day-to-day basis, but enforcement mechanisms like this are a powerful tool. They're an important part of what we do, even if it's not necessarily what I'm going in court on a given day to argue for or against. The knowledge that there's enforcement somewhere in the process is an important, the entire child support scheme has to be viewed as a whole. And so, yes, we consistently, and we have consistently taken positions that support the existing scheme we have. To the extent if there are changes to the child support that are appropriate, that are reasonable, we have advocated on behalf of those in the past. But where we see a bill that, in our opinion, will undermine the ability to collect and enforce the obligations that do exist, we, in our discretion as an organization, may choose to oppose it, as we've done here.
I'm a member. I just wanted to make sure. Thank you. I believe this concludes the panel on this bill. We're going to move to the next one. Thank you.
I know.
Here now.
Thank you. I believe we have
Okay.
the panel for Delegate Simpson here. It is HB 497.
I don't know.
Madam Vice Chair, we've lost a few people. So we're asking if we can just combine our panels, because now it's just us here.
Well, if it's the sponsor's discretion,
Yeah,
it's fine with
it's
me.
fine, because everybody, and you all, I'm sure, would like to leave, so.
We thought this would be more expeditious.
We would like to eat today. All right, you may proceed.
So House Bill 497 is new, so it's good to see my family again so quickly. This is actually legislation that was requested by the attorney, so I'm going to turn it really quickly over to individuals. This was kind of a wish list of, you know, what will make things go better when it comes to a temporary protective order or comes to a final protective order. And we did look at other states and see that other states do extend the time from the 7 to 14, and then understand when it comes to some of the funds that we're talking about recouping. So in other words, if they banged down the door and broke the door, or they threw the cell phone or something like that, something that they really need right now, this would allow the courts that discretion. So I will then turn it over to, I hope you will give a favorable report, give them their wish list, and thank you very much.
Thank you, Delegate Simpson, for bringing the bill, and thank you, Madam Vice Chair, members of the committee. I really appreciate your patience. I know everybody, including me, is hungry and tired. My name is Lori Ruth, for the record, from the Maryland Network Against Domestic Violence. I also wanted to say this bill is one of MLAW, Maryland Legislative Agenda for Women's priority bills. The House of Ruth has submitted testimony. They can't be here. They're going through somewhat of a transition. And certainly Lisa Jordan was here until she had to leave for MCASA, and Katie O'Malley was here for the Women's Law Center until she had to leave. So now I've used up all my time. But I just wanted to tell you very quickly the genesis of the bill. The Pro Bono Resources Center provides once a year a Partners for Justice conference. It's the only conference in the state for legal service attorneys and advocates. And I was asked to present last year in May on a domestic violence panel. And at the end of it, we had been talking at them. So I said, let's let you all get some oxygen. If you could do anything you want to improve the protective order statute in Maryland, what would you do? And the two components of this bill were the two biggest asks of that group of probably 50 lawyers and advocates who work with domestic violence survivors every day. As Delegate Simpson said, the first piece, very simple. It would extend the temporary protective order to final protective order time from 7 days to 14 days. We are woefully behind the rest of the country. Only Wyoming has a shorter amount of time than we do. And Ms. Vora was very useful and prepared a whole chart and had something to say about that. The other thing it does is add relief to the relief part of the statute for financial loss. And essentially, as Delegate Simpson said, it's something that the incident of abuse, the abuser caused damage, something that got, ruined, perhaps an urgent care visit if there's physical, and it would allow the court at the final protective order stage to order that respondent to pay back that limited emergency urgent amount of money. I'm going to let the rest of the panel speak because they have more specifics, but I do urge you to ask any questions because it's a little bit detailed and not everybody understands it perfectly. So thank you very much. We strongly urge a favorable report.
Thank you. Next.
Yes. Good evening again. My name is Ami Vora, Advocacy Director for Family Law from Maryland Legal Aid, where our attorneys represent survivors of domestic violence day in, day out in protective order cases around the state. We're here to urge a favorable report on this bill, which will improve Maryland's protective order laws in two crucial ways that have already been adopted by many other states. First, this bill will increase the window of time between TPOs and the final hearing on a protective order request. It'll increase it from 7 to 14 days. Our 7-day window poses a huge practical burden to the judiciary, to law enforcement, and to the litigants themselves. It's just not enough time for the sheriffs to be able to complete and locate and serve a respondent with the paperwork for court, and that's been leading to a lot of delays and postponements. And so this bill will actually lead to the faster resolution of cases. It will also give both parties more time to prep for their hearings, more time to hire a lawyer to get their evidence and their witnesses in line. And then finally, this 14-day window will bring us into line with what most other states in the country is doing. Every other state except Wyoming has a window that's larger than ours, and the 2-week specifically, the 2-week duration is the most common window that is used in other states. So we need to catch up here. This bill will also allow respondents to pay for financial losses incurred by the petitioner as a result of the abuse. Again, this relief is available in many, many other states. I used to practice in the District of Columbia, where both the 14-day TPO window is available and this financial relief provision is available. And I can tell you, it does not lead to these lengthy, complicated hearings or heightened conflict. It actually enables the court to, in a consolidated way, efficiently address the full scope of harms caused by DV in a single court case. And I'll just wrap up very quickly. As you've heard, DV so often results in broken property, unexpected medical bills, moving expenses. This bill will hold abusers accountable for their financial wreckage without passing on the burden to taxpayers through the Crime Victims Compensation Scheme that we already have, or the victims themselves. And so for those reasons, we urge a favorable report.
Sir, we don't have you on the list. What is your name?
My name is Nicholas Steigerwald. I'll be speaking for Amanda Rodriguez.
Madam Vice Chair, they called Chair Bartlett earlier today, and she said that it was okay, because Amanda had a family health emergency. If you'd like to confirm, you can. And they did submit written as well, but.
Okay, proceed.
Okay. My name is Nicholas Steigerwald, and as I said, I'll be speaking for Amanda Rodriguez. Both her and I are part of Turnaround, which is a comprehensive domestic violence provider, designated rape crisis center, and human trafficking services provider for the greater Baltimore area. Amanda also serves on the Maryland Human Trafficking Task Force. And today I'm going to give a little bit of a story for context from one of our survivors at Turnaround. This survivor was sexually abused by her father over multiple years, and shortly after her 18th birthday, she made the brave decision to walk to a police station over several miles from her home to get help. When we received that referral at Turnaround, we immediately went to work, and in addition to securing emergency housing and addressing her health, medical, and mental health needs, we began filing protective orders. The respondents in those protective orders were her father, as well as multiple family members who had threatened to hurt her if she exposed and told the story of the abuse that she was suffering. As in many of the cases, protective orders that we file, her safety was our first priority, so we needed to file immediately. We went to work attempting to locate an attorney. With only a week to work with, it was impossible to find anyone to assist, and that was with the support of a victim services agency. We called 5 different legal providers. Most of the time, survivors don't get to us until after they've filed these temporary orders. 7 days is simply too short of a time for survivors to access legal support, especially given the fact that many of them also have more pressing housing and physical needs in that moment. Additionally, this client's case, she had no monetary support whatsoever as a result of the type of the abuse that she had been put through. This bill would allow her to have some financial support while she was navigating her very young life moving forward. We really hope for a favorable report.
Thank you. Thank you.
Brendan Madden again on behalf of the MSBA, and I will hopefully
Welcome to the table.
Yes. I will hopefully improve Delegate Simpson's opinion of me. The MSBA supports HB 497. We agree with the extension of the time frame from 7 days to 14 days for the duration of the temporary protective order. Many members of the section have expressed that they are hard-pressed often to accept these cases when they come in the door because of the short time frame, and many attorneys even have a blanket policy that they will not take on protective orders because they will not have enough time to prepare, and they're worried about, you know, their obligation of competence and diligence. So this would ameliorate that problem. As you've heard from the other advocates, more time to prepare is a good thing for both sides, petitioners and respondents. As to the second portion of the bill, with regards to the monetary relief, and we've heard some concern about, and I know there is opposition to the bill from the judiciary about the scope of that relief and its place within the protective order, you know, proceeding. The family law section is not concerned about this overextending the hearing, that it's too much. This is a limited remedy, as you've heard. It is relief for damages that are directly caused by the abuse, which I believe direct is in there somewhere, but there is a limitation to what happened in the immediate moments, the days, weeks, where the abuse that leads to the order occurred. So we are not concerned about our ability, certainly as practitioners, or the ability of the courts to appropriately implement that provision. So we would urge a favorable report.
Thank you, sir. Delegate Valentine.
Thank you, Madam Chair. Thank you, Delegate, and thank you, panel. And I think this should be easy for the delegate to explain or answer my question. And feel free to have either of the panel members. So the main reason for the 7 to the 14 days, I just want to be clear, is 1, it'll help to secure counsel. Is that correct? And 2 is for the ability for service of the order. Those are the 2 main reasons. Is there any additional reasons other than those 2?
Those are 2 reasons, Delegate, but I will say I think the primary reason, as voiced by the people who were at that conference and as those of us who work with these, is that the victim at that time has a lot going on in their life. Right. They may be seeking rehousing. They may need to get care for their child. They may be trying to keep their job at the same time. They've got a lot going on, and so that 14 days will give them the ability to address things in a more easy manner while they're also dealing perhaps with medical issues and trauma itself. So to me, the side benefit is that it will improve law enforcement service and hopefully reduce postponements and the need to postpone for both sides. Because when we do these cases, sometimes they don't get served until the night before. The respondent doesn't get served until the night before. They come in and immediately ask for a postponement. And of course the court is going to give it to them. But if law enforcement is able to serve them and they've got 5 days, 6 days, 7 days, hopefully they can get a lawyer and the victims can get a lawyer. So that's a side benefit. Perfect. In my view.
I only know one other that I read from other states, which is the longer that we give them for safety, that additional time gives them a little longer for safety, and the more time that we increase the safety, the more likely they are actually to become safe. That's the only other reason that I know of. And then just to add on to what you said about the serving, because not everywhere in Maryland is as easy and is accessible. So all 24 jurisdictions, as far as serving folks, is, some of them want more time.
And especially when you go in between counties, when law enforcement in one county has to coordinate with another county for service because a respondent lives elsewhere, forget about 7 days. Like, you're talking about a month to get that completed.
Thank you. Thank you, ma'am.
Thank you. Delegate Congola.
Thank you, Madam Chair. So does the temporary protective order of the current law expire after 7 days?
No. Yes and no. If you go to court on the day that your final is set in, that means a second appearance for that petitioner, the court can then extend it for up to 6 months. You don't usually see that unless the respondent is trying to evade service, but it stays in effect, it stays live. It doesn't become effective until the respondent is served. So it's there. If you can find the respondent and serve them, it would become an active order until the final protective order hearing date. But it doesn't become effective until the respondent gets service from law enforcement.
Delegate McComas.
Just real quick. I assume everybody's had an opportunity to read what the, okay. So you would be okay with working with them if you can get some more help financially if there's, medical issues or something? Or you could just delete that and just have it at the extension of time?
I just want to clarify your question. Are you talking about the judiciary's opposition? Yeah. And are you talking, they don't oppose the 7 to 14 days.
No.
So
it's the other
just
part.
to make that clear, they are not opposed to the 7 to 14 days. As far as the relief part, I said on the Senate side and got called out by a judge for saying I think they're making a mountain out of a molehill. And I think Ms. Vora could actually tell you that in the District of Columbia, it is of no moment to add this level of relief, while it can really help a survivor who might have only that money to pay the rent or buy food and then has to replace their phone because of child care needs or whatever. So in terms of...
Can you then rejigger the language that they'll be happy with?
We have discussed it.
Okay.
And we will bring it to them if it's necessary. I would love to talk to the subcommittee here about it as well when it comes up in the subcommittee. But I think fundamentally they are imagining something that is certainly not intended. It is, as Ms. Vora said, it's a very, and Mr. Madden, actually, it's just a very narrow thing. They already have to hear the testimony. He punched me in the face and threw my phone against the wall and it broke and I had to replace it. The only addition to this is how much did it cost and do you have a receipt? I just don't believe that in these 20 other states we've seen any demonstration that the courts have fallen apart and been unable to function, which is essentially what they are suggesting.
It's Maryland, though.
Well, right, but we are in Maryland, yes, but I just think it's a false fear of theirs. So we do have a little bit of language that might help if it comes to that, and I'd love to engage in a conversation with them about it. Thank you.
Thank you, Madam Chair.
Okay, I don't see any further questions. Oh my gosh, I did it to Frank again. Delegate Conaway. I think you did it on purpose.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So Party A gets a temporary protective order against Party B. Party B has to be away from the House for 14 days if this passes. Party B stays at the hotel for 14 days. It goes to court and the final protective order is not given. So now Party A could be held responsible for the hotel stay, the lodging for Party B?
Not under this bill.
Not under this.
Not under this bill?
No.
Right.
Just goes one way.
Thank you.
That's a remedy that they can pursue elsewhere, but that's not within the scope of what this bill does.
Okay. Thank you.
Okay. Delegate Conway, you have another question? No. That concludes the hearing on this bill. Thank you so much for coming and staying late. That concludes our work for today. Thank you.
Thank you so much.
Thank you.
Thank you.